we're going to get started, please. We have a very full agenda tonight. Good evening and welcome to the monthly meeting of the Arlington Board of Zoning Appeals, also known as the BZA. I'm Judy Freshman, Chairman of the Board. The Board's made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Charles Smith, Inta Malis, Paul Melnick, and Peter Owen. Also present is a professional staff, including Amanda Clement, who serves as Secretary to the Board of Zoning Appeals, Arlo Vavon, Zoning Administrator, Blake Bowen, Simon Keynes, and Cedric Sutherland, Assistants to the Zoning Administrator, and also Min Shao Kaur, Assistant County Attorney. We thank you for being here and extend a warm welcome. To avoid disruptions, we ask that you please turn your cell phones or pagers off or put them in silent mode. On the front table, you'll find copies of the staff report for each case before us this evening. I recommend that if you've not yet seen the report for your case, that you get a copy and review it before your case is called. The Board's powers are prescribed in the Code of Virginia and are set out in further detail in the county zoning ordinance adopted by the County Board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests with the County Board. The Board does have the authority to do 3 things. We can approve use permits that allow modifications of placement requirements for structures on 1- and 2-family lots where there is no option in the zoning ordinance to allow such modifications. We can grant variances from the specific requirements of the zoning ordinance, and we can decide appeals of decisions of the zoning administrator. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the law requires that the Board find that the proposal meets conditions and that the use permit will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plans and land use and zoning related policies of the county. To do this, the BZA shall consider whether the modifications will promote compatibility of development with the surrounding neighborhood because the structure's overall footprint size and placement are similar to the structures on the properties surrounding the lot in question, and whether the modification will help preserve natural landform, historic features, and/or significant trees and foliage. When granting variances, the Board must determine that the strict application of the ordinance would unreasonably restrict the utilization of the property, or that the granting of the variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon, that the hardship is not generally shared by other properties in the same zoning district, and that the authorization of the variance will not be of substantial detriment to adjacent property, and the character of the district will not be changed by the granting of the variance. A Supreme Court ruling requires that a variance cannot be granted unless the effect of the zoning ordinance, as applied to the piece of property under consideration, would, in the absence of a variance, interfere with all reasonable, beneficial uses of the property taken as a whole. When deciding appeals of the zoning administrator, the Board must determine if the administrator acted correctly. This evening, cases will be called and a brief staff report and recommendation will be given. Following that, Board members will ask any questions of the staff they may have. Next, applicants or their representative will be given an opportunity to make comments to support the application or appeal. If they choose to make a comment, they must come forward to the podium so their comments can be recorded for the record. Next, all speakers for the item will be called. Speakers must fill out a speaker slip, which is available on the table in the front of the room. After we hear from speakers for and against the proposal, the Board may permit the applicant a brief opportunity to clarify any points. The Board may ask questions of any speakers, but does not permit and will not condone any cross-examination or direct questioning by others. We have deemed the following time limits for speakers to be sufficient: 20 minutes for applicants of appeals, 5 minutes for applicants of use permits and variances. For use permits, variances, and appeals, we have deemed 3 minutes for representatives of organizations and 2 minutes for individuals as sufficient. After the board has gathered all the information they need and discussed the case, it will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you're welcome to stay for the balance of the session or leave at your convenience. Again, thank you for being here this evening. Please call the first case.
Case V-11216-16-APP-1, an appeal by the Berkeley Condominium of a violation notice stating that the condominium was in violation of site plan number 352, condition number 64, requiring a permanent public easement to have been granted at the premises known as 1000 North Randolph Street in the RC zoning district. Staff is not going to make a formal presentation. We just recommend that the BZA find that the violation notice was issued properly and uphold the decision of the zoning administrator. And we're happy to take questions you have at this time.
Thank you. Questions for staff? Mr. Owen. Mr. Melnick.
I would like to make a disclosure, and that is that I'm a trustee of a trust that owns property on North Randolph Street at 1022. And I'm feeling like I'm going to need to abstain from voting on this.
As you wish. Mr. Owen.
I do have a question, maybe at least one question for staff. In your report, you stated that the violation notice followed in time after a complaint that was made, and that somehow relates to this, but the report did not go into detail about the nature of the complaint or the investigation. And I'm curious to know what you can tell us about the nature of the complaint that was made or the circumstances that led staff to discover what the violation notice was issued for.
I'm just pulling up my notes that I forgot to bring with me. The complaint came in from a citizen after, I want to say, a gate was installed at one edge of the walkway, and there was concern about being able to, because it had a lock on it, and there was concern about being able to continue to use it if it was going to be locked. And so that's how it came in. Then our enforcement staff looked it up and determined that there was an easement, and then looked further and determined that an easement was required, and then went further and investigated that it was never recorded.
Thank you. That's very helpful.
Sure.
Any other questions, comments? We're here.
One
Mr. Smith?
question. Ms. Bond, did you just say the easement was never recorded?
The public easement.
Okay.
Okay. Mr. Lawson.
Thank you, Madam Chairman. For the record, my name is William B. Lawson, Jr. I represent the condominium. In our appeal, we presented our case fairly clearly, I thought. So what I thought I would do is use the majority of my time to rebut the county's rebuttal, so to speak. And if you all would go to page 3 of your staff reports. On page 3, zoning administrator's position, what they do is pretty much discuss each one of the 4 points that we made. So I'm going to talk about those in the order of the staff report. On page 3 in the first paragraph, I would submit that the county really has not rebutted our argument. They simply say that it's possible for us to grant the easement. And I'd like to point out that later in the staff's analysis on page 4, in the final paragraph, what they say is, it is well established that the zoning administrator and her staff has no authority to modify the board's site plans. And that's very interesting because the argument that I made was that we can't comply with the site plan. If you look at the wording of the site plan, there is a sentence and it says, landscaping of this area and granting of the public access easement shall be completed prior to the issuance of the first certificate of the building, first certificate of occupancy of the building. Well, we can't go back in time and do that. And so, the staff can't have it both ways. If this can't be amended, well, then they can't amend it by dropping that sentence. And so it's impossible that we comply with that, with that site plan condition. On number 2, the county is basically saying, well, yeah, it might be hard, but you can get the owners to grant the easement, and in any event, you can apply for a site plan amendment. I've been told in confidence by a county employee that the inspector who had this project had to be terminated due to he just wasn't doing the job. And so we've had countless, this has come up this is the third time this has come up, that there's been a problem that the developer did not do. And it wasn't us that made these errors. And so we reached out to the county and we said, okay, we'll file for a minor site plan amendment, but with all due respect, we think you should waive the filing fee. County said no to that. We then said, okay, look, we're perfectly willing to grant the easement. We just want to lock it off at 10 o'clock at night when all this criminal activity starts taking place. County said no to that. Our owners are not going to vote to grant access to the rear of this property and let this criminal activity continue to take place. With due respect to the county, if this is so important, they can condemn the easement. I would also like to note that when I've been an expert witness in condemnation cases, the county attorneys never allow testimony about land use approvals because they're speculative, and I would respectfully submit that's the same thing that we have here. As to our third issue, there's no rebuttal by the county. Again, basically the county says that we need to comply. And I think the reason that it's not rebutted is how can it be? It's crystal clear. When you look at the Arlington County zoning ordinance, it says, every certificate of occupancy shall state that the building or the proposed use of a building or land complies with all provisions of law and of county ordinances and regulations. So the county analyzed it and they concluded everything was okay. The zoning ordinance further says, said certificate shall be issued within 10 days, provided it has been determined that such occupancy, use, erection, or alteration of such building or land or any part thereof has been complete in conformity with the provisions of the zoning ordinance. That's what a certificate of occupancy means when it is issued. Getting on to the fourth point, and the county attorney has made a lot of arguments that I would respectfully submit are off point. They really aren't applicable to the situation and to what our argument is. I was involved in the case of Gwynn versus Allward. And what happened in that case was Jane Gwynn reversed a prior determination by Phil Yates that he had made 10 years earlier that a piece of property could be used as an auto repair establishment. When Jane Gwynn did that after 10 years, the industry went to the General Assembly. We said, we can't live with this. And so Virginia Code 15.2-2311C was passed. And I think you all are familiar with that. What that says is that when a approval or a determination or decision is made by a zoning administrator, and you rely on that in good faith, after 60 days, that can't be changed. And here, this is the situation that we have. We have a building full of people, a condominium full of people that have bought their units based upon the assurance that they were given that there aren't problems such as this out there. You know, when you buy a condominium, I know several of you have, when you buy a condominium, Virginia law requires all kinds of disclosures. You have a right to review the budget. You get to see what's going on. The condominium has to tell you about any outstanding issues or problems or lawsuits or anything of that nature. And so people buy with the understanding that what they're buying is in compliance with zoning. And this is why this code section got passed, so that later zoning inspectors or zoning officials won't come back and say, oops, sorry, big mistake, you need to do A, B, C. I'd like to read from the certificate of occupancy. And when the county gives you your certificate of occupancy, it says, the building or the proposed use of the building or land complies with all provisions of the Virginia Uniform Statewide Building Code and the Arlington County Zoning Ordinance. I'm going to finish up my presentation by reading from another appeal I was involved in. If you all would go to page 2, in about the middle of the page, there's a sentence, and it begins with, it was only about the background. It's right about here, about in the middle of the page, and about the middle of the page this way and middle of the page that way. It says, it was only about the background. Do you all see that? What's going on here is...
It's page 2. It's like
On
right
the-
there, right here.
On the
Right
page
here.
numbered 3?
Page 3, I'm sorry, it's the second page of what I handed out. It is page 3. It begins with, it was only. What this was a building permit was given for a deck, and a neighbor made a complaint about that building permit. And no response was ever given, and so she finally raised so much cane that she got an answer from the assistant zoning administrator, and an appeal was filed. And this is an argument being made by the county attorney. And what the county attorney is saying is that there wasn't any ability of the BZA to change the fact that this building permit had been issued, and this building permit was a decision. So here's what they're saying. It was only about the background, that what was going on in the zoning administrator's mind when she made the decision, but the decision had been made. That's the issuance of the building permit. The decision has been made. And the decision was made, and the appeal period lapsed without anyone making an appeal. And as I'm sure you all know, under 15.22311C, which is what I just talked about, once the appeal period has passed, the zoning administrator doesn't even have the authority to change a previous decision she has made, which makes it even clearer that this phone conversation had absolutely no possibility of impacting the appellant's rights. So she is not an aggrieved party. And the last thing I want to point out is that there is a reason for these time limitations on appeals, and it's not simply a burden that the county imposes on people. It's simply that in any conflict or in any case like this, there are two sides here. And the parties have a right to know when a thing is finally decided, when their property interests vest. And in this case, the property owner spent considerable time and money to get this permit approved. She relied on the final approval of the permit without an appeal. That's exactly what we have. And the county attorney just made a great argument, which is exactly the argument I just made. So I would respectfully suggest that you all need to reverse this violation notice. Thank you very much.
Thank you. Questions for Mr. Lawson?
Maybe the attorney.
Ms. Malice?
Mr. Lawson referred to condemnation of the appeal of the easement. Do you know what that refers to?
I'm assuming he's referring to the possibility of us condemning the actual property,
Of what?
of us condemning the actual street to acquire it, which the reason we have these site plan conditions is so we don't have to take that route. It's
So the-
rather extreme.
An alternative would be a condemnation of the passageway.
I don't know if it's even a feasible alternative. I really can't. I mean, that's a elaborate process that I can't really speak to whether we would actually do it.
Another question I have is, Mr. Lawson referred to there being a time period for appeals. Is there a time period for correcting errors?
There is a time period for correcting errors as far as determinations of the zoning administrator. There is not for site plans and violations of site plan. The reason we cited this violation is because it's a violation of a site plan condition, and those last for the duration of the site plan. They don't, it's not, you have to catch it within 60 days.
Mr. Lawson.
The point that I made when I was talking about the condemnation is the county saying, well, you could do a site plan amendment. And I'm saying, yeah, okay, and you can do a condemnation. That's irrelevant. What we're here for is this violation notice. And a site plan is a special exception. And those are special exception conditions, and it is the zoning ordinance. And so there's no difference between a site plan condition and any other provision of the zoning ordinance.
Other questions? Mr. Owen.
Mr. Lawson, I have a couple questions for you, if I might. Mr. Lawson, do you know if, following up on my question I had to staff before we started, is it true that there was a fence or a gate of some sort recently installed?
Yes, what happened is, you all are familiar with A-Town?
Yes.
Okay.
I haven't been there, but I'm familiar with it.
A-Town reared its ugly head. I live in Alta Vista, so I'm unfortunately very familiar with A-Town. When A-Town reared its ugly head, the condo actually thought the easement had been granted, and people had been going through there. There were no problems or anything. And so when A-Town opened up and they started having all this, it's criminal activity that was going on back there, they put a gate up. They didn't lock it, but they put a gate up, and the purpose of it was to try to stop people from going through late at night. They don't have any problem with daytime or evening. The problem is 10 o'clock, 11 o'clock, 12 o'clock at night when people are going back there and they're smoking dope and doing all kinds of stuff, stealing things.
Actually, your response, thank you for that. And was there any further change in 2016 to that condition? To the physical conditions on the site? Did the condominium make any further changes to the fence?
The several board members are here to speak, and I would suggest you ask that. I'm not aware of any.
Oh, we have additional speakers?
Many.
Oh, I'll withhold the rest of my questions till the speakers.
Okay.
Questions? Okay. We'll go to the speakers. There are 13 speakers. So I'm going to call two names. The first person come up, the second person come up to the front and be ready to go so that we can keep moving, please. First speaker is Richard Spencer, to be followed by Charles Richter.
Do I just make my statement here?
Yes.
Okay. Thank you. I appreciate the opportunity to speak. I purchased my unit in May of this year, and again, as Mr. Lawson conveyed, I obviously purchased with the assumption that the building was compliant with all legal requirements. So it seems to me that for the county to come back now after having approved the site plan for the building as far back as 2001, it strikes me as very unfair to the residents now to come back after so much time and assert that the county has a right at this time. And it goes to the broader question of setting a precedent for the county that when can the public rely upon the county's decisions? I mean, if it waits 15 years, everyone's in pins and needles for 15 years to know what is the status of my property. So I feel that's very compromising, and I've subsequently learned this legal idea of lashes. So if someone doesn't assert a right within a reasonable time, then they really should be deemed to have forfeit that right. And this seems to be a classic example, almost a textbook example of that kind of a prohibition, and that seems to me would apply. Thank you.
Thank you. Charles Richter, to be followed by Mark Smith.
I'm Charles Richter. I purchased a unit in the Berkeley 5 years ago, and I did all my homework. I read all of the documents, and I understood very clearly that all the papers were in order. I think it's very unfair for the board to come to us, or to come to the condominium many years after the certificate of occupancy was issued with a statement that something wasn't done correctly. I feel it's very unfair to have to suffer and pay the costs associated with the easement being granted. But also, I strongly support my neighbors in all the consternation they've had to face with drunks, with problems at night, public urination in the area. The area has become a difficult one. I've listened several times to dog fights, to owners arguing, dog owners arguing with each other about what their dogs are doing back there, and it's sort of become a nuisance area. And I think it would be very appropriate to have it closed off. Thank you.
Thank you. Mark Smith, to be followed by Michael Goldberg.
Good evening, Madam Chairman. I've been an owner at Berkeley for about 2 years now. I'm on a first floor unit that faces the back patio, and as a couple of my neighbors are going to testify tonight, that back area prior to the gate being put up has been a constant nuisance. There's been incidents nearly every single week, especially on the weekends. You see men and women urinating in the back. You see women on the bench throwing up. You see drunk men stumbling through bushes, knocking over shrubbery. In one case, I saw a man urinating on my neighbor's patio, right out in the open, no regard for any of the neighbors that might be looking out in the back at that point in time. But probably one of my most troubling incidents that I've encountered since I've been there happened on it was either Wednesday or Thursday night. And I was going to bed about 11 o'clock or so. As I turn off my bedroom light, I see a silhouette above my bed, which faces the back patio. So I go over to look at what's going on here. As I open up the window, I notice a girl wrapped in a blanket sitting on my windowsill. She's digging through her purse, tons of small bills in there, denominations, and I don't know what's going on. So I'm standing there for 2 or 3 minutes, and she doesn't even realize that I'm there. So she's obviously drunk or drugged up. I don't know what the case was, but I walked around to my living room and turned on the patio light, and she ran away. So I opened up the back door, looked out there, and I see a spoon sitting on my railing. Being a law enforcement officer, I could tell you when you see small bills like that with a woman who's unresponsive to being behind her, and then you see drug paraphernalia there, you put 2 and 2 together, and there's drugs there. So my question is, what's going to happen next time? Are you going to see syringes left out there or see bags of heroin? And I don't want any of my neighbors to encounter that while they're out using and enjoying the area. Thank you.
Thank you. Michael Goldberg, to be followed by Eric Holloway.
I'm the secretary of the Unit Owners Association and a member of the board. This is not the first nor the second. This is the 3rd time that the county has come at the association to fulfill a promise that the developer made to the county, that the county failed to enforce against the developer. Now, whatever motivated the county and the developer to come into agreement on this site plan some 16 or 17 years ago, the circumstances are different. There was no tavern across the street then. There is now A-Town, and you've heard the mention of it. And I think the board has to look at the conditions that exist now, not the conditions that existed 16 or 17 years ago when it issued the certificate of occupancy that didn't exist at that point. And these are not hypothetical problems. There, as you've heard already, and there is testimony from the owners of the several units that are on the ground level that open out onto this garden area. They are harassed by people coming onto their patios, urinating and vomiting in their patios, getting into arguments late at night. This is not what we all bought into when we bought our condominiums, and this is not what the county should be encouraging us to provide access for. As I said, these are not hypothetical situations. I'm lucky. I live on the 8th floor. 8th floor. My apartment backs out onto this area, and I can't tell you how many times I'm awakened at 2 in the morning by people vomiting, urinating, arguing, trying to figure out where they parked their cars. This is a nuisance and a hazard, and we should not be made to make this area available to drunks and vagrants.
Thank you.
Anybody questions for me? So you have a question for the board? I'm sorry, Mr. Owen.
Well, since you've invited, thank you very much for your testimony tonight. And my question is, has the condominium in this calendar year, in 2016, or in the last 12 months, has the condition of the gate or the fence been changed at all? Have there been any new impediments placed to how people can get through?
The answer is no, none. The fence and the gates were put up. They're unlocked, and there's been no changes since then.
And as far as you know, they've never been locked. Is that right?
As far as I know, they have never been locked.
Okay, thank you.
Eric Holloway, to be followed by Solange.
So my name's Eric Holloway. I've been an owner at the Berkeley for about a year now. Thanks for the opportunity to speak before you today on this issue. It's of great importance to myself as well as the other homeowners of the Berkeley condominiums. As an owner at the Berkeley, I'm here to appeal to you regarding the zoning board staff demand to provide a public easing through our back garden. In other words, this is a demand to allow the general public to walk through what we consider our backyard, and it's something that many homeowners would not relish for a lot of the reasons that you've heard. By allowing the general public access to the building's backyard, I'm deeply concerned about the negative impact to safety, quality of life, and the property value of the home that I've worked so hard to purchase. The activities from Maytown's customers already impact the public sidewalks with loud and drunk individuals. Empty pizza boxes, empty six-packs of beer are stacked around trash bins on the public streets. Providing public access to the Berkeley's back garden will transfer these sort of behaviors and problems into that area. In addition, as noted, the condo board has tried to work in good faith with the zoning board to come up with a compromise, which was rejected. And then finally, I also wanted to mention that this really is an issue of fundamental fairness. The zoning board staff issued the master certificate of occupancy 15 years ago, indicating that the developer met all its obligations. And really to come back after so many years and make these sort of demands, it's really unreasonable. And while the public good of providing a public easement for a back garden, I think it's hard to articulate what those public goods would be. The negative consequences for the homeowners are very real. Thank you for your time.
Thank you. Yes.
The previous speaker, I don't know if you said something on purpose or by accident, but you said that you've tried to compromise with the zoning board?
Well, as I understand, the first speaker mentioned the zoning board to try to figure out some sort of...
I think that's, the reason I wanted to clarify that is we're the zoning board.
Okay,
and
I meant the staff.
We didn't participate in that.
Yeah.
The Arlington County Board, the elected officials, I believe was what Mr. Lawson was referring to. So it's a different governmental body than we are.
I stand corrected. But my point remains that we did try to reach a compromise with the authorities.
Mr. Smith.
Thank you, Madam Chair. I should have asked this question, I think, of the prior speaker, the secretary of the board, but probably anyone who lives there. Are there any signs, when we're looking at that, are there any signs that say no trespassing or do not enter?
No.
Okay.
No, there's no,
Okay.
there are no signs or no indication.
Thank you.
Thank you. Solange, I apologize. I cannot read your name. Please state your last name for the record.
Ease. Solange Ease.
Thank you. To be followed by Andrew Miller. Go ahead, please.
I've been living at the Berkeley for 6 years, and I work at my computer every night very late. And even though my unit is on the 7th floor, I can testify to numerous cases of people you've heard so far. And once I did call the police because I was afraid that this woman would be raped in our garden. And the police took more than 20 minutes to arrive. I had to call again. And this man is shouting, and I thought he was hitting her. And the police arrives and just ask, ma'am, can you come over here to the car? And are you okay? And of course she says, I'm okay. But as soon as the police left, he started again doing the same thing. I called the police again, and then they moved to another area. The police asked them to move, to keep going, but they went to the townhouses in the back. I have seen homeless people using the bench, and my point here is it is dangerous for the units that are on the ground level. I don't see this area that the county wanted to make it public as a place that people would use like a park or a cut-through like we have alleys. The building is on the corner of Fairfax and Randolph. There's no way they can cut through to say, oh, we're saving time here. I think it would be very good for safety to close that gate. Safety for people that go to a town and are drunk.
Thank you. Andrew Miller, to be followed by Bob Johnson. Oops.
Hi, my name is Andrew Miller, and I moved to Arlington a couple of years ago so my son could attend Washington and Lee High School. I have to tell you, I love Arlington. I love my neighborhood. I bought a condo in the Berkeley about 6 months ago. I actually bought the most expensive condo in the building. I took every penny out of savings to do it, and I see it as an investment, and I like to protect my investment. You know, you've heard enough stories from people with trouble, so I'm not going to repeat that. But I will say I'm a bit of a night person, and I walk around the neighborhood at 2 o'clock in the morning. That's 7-Eleven. It's a good thing it's open 24 hours. But, you know, I've been a property owner before. I've owned a house. I'm sure everybody or many people in this room own houses and own property. And I don't know what it was like 14 years ago, but I do know now that if you were building a home in my neighborhood right now, there's no way you would build a house and allow anybody who wanted to enter into your backyard at night. It's just not something a prudent person would do. This is a city. I don't know what it was like 14 years ago, but it's just, if you would think about it from the point of view that you wouldn't let other people into your backyard at night, and believe me, I've seen some characters around the neighborhood, there's no reason why we should be forced to. That's it.
Thank you. Bob Johnson, to be followed by Kathleen Bergen.
Bob Johnson, I'm an owner of 2 units in the building, and I've lived there since 2004 and bought a larger unit and rent out the other one. But I have excerpts from 4 owners and then followed up by a couple points in my own, since the 4 owners couldn't be here tonight, but they wanted something said on their behalf. First is Mr. Akshay Pandit of Unit 906. He said Arlington County has already received numerous complaints dealing with the public nuisances created by A-Town and its clientele. To open a heretofore private area to drunks and strangers creates a larger public safety issue than benefit. Mr. Naveen Rao, Unit 903. Any public benefit is very unclear. There's no beachfront property back there. The only ostensible benefit is a path between Randolph Street and Fairfax Avenue, which are already quite connected and accessible with a negligible difference in distance. On the other hand, the significant costs and burdens of providing the easement will be shouldered by a select few people. Ms. Sarah McCorkle of Unit 806, your board's willingness to open the guard during daylight hours and bar it at night for the safety and security of Berkeley residents is a far more than fair offer to reach a compromise between the Berkeley owners and the board. Mr. Amit Sheth, Unit 104, I purchased my unit in March, April 2015, so being a relatively new homeowner, the special assessment would be difficult. The Berkeley is a family environment with friendly occupants and neighbors who are kind, courteous, and never cause any problems for the surrounding community. Hope the zoning board considers these factors and provides a favorable decision to the Berkeley owners when there's fair and considerate. And now points of my own. Bad experience I've had back there. I live on the 9th floor overlooking the courtyard. One day I heard a commotion, dog fight was ensuing. Then the two humans with the dogs got into a fight, so I ended across the street one afternoon at court testifying to what I saw at that. So the access for the public is bad. To give some scale to the walkway is between 15 and a half and 18 feet from the patios you see. And just finish it up, the intentions many years ago were good for having a public access, but maybe in hindsight, the application in reality didn't work out so well.
Thank you. Kathleen Bergen, to be followed by Yvonne Liu.
Thank you for the opportunity. I'm the first person to have moved into the Berkeley, and I have loved living there since 2004. But this is making it a very difficult situation. First of all, and I'm going to repeat some things that have been said, but I feel that they bear repeating. The developer failed to provide the easement 15 years ago. The developer should have paid the cost rather than asking the Berkeley homeowners now to pay the cost to have it surveyed, to pay the cost for the filing fees. The county failed to obtain that easement prior to giving the occupancy certification. So the burden should lie with the county. The circumstances today are different in terms of our safety and our security and the value of our property. We've tried to offer a compromise. The gates have never been locked. We asked permission that we be allowed to lock them at 10 o'clock at night to dissuade some of the horrible behaviors that you've seen or heard about here. There's disruptive behaviors. We've made a good faith effort to be in compliance with zoning. But the responsibility for what has occurred lies elsewhere, and to burden the owners of the Berkeley with paying for something in order to have the kinds of criminal activity occurring in our back garden, and I invite you to come see our back garden, is unreasonable.
Thank you. Yvonne Liu, to be followed by Thomas Palumbo.
Good evening. I have lived in the Berkeley condo for over 15 years. I obtained my loan, purchased my property based on the belief our building has always been in full compliance with the county zoning, whatever ordinance there is, because based on the fact that there is the master certificate of occupancy. So based on knowledge, I bought not only one unit, I bought 2 units. So I have been living there for 15 years, and now the county is saying, the Berkeley building fell short of the compliance from the very beginning. And I felt I have been misled, and I've been injured because I had to pay extra incur extra costs to be in quote-unquote compliance. So I don't think that's fair. I'm a homeowner. I'm not a developer with deep pocket for the county to come back to, after 15 years of issuing the master certificate of occupancy. I have been paying my annual assessment payments to the county based on the assessment that is now, overly priced because the county, the building wasn't in compliance according to what I hear from now. So I've been paying an assessment way too high for 15 years. So alternatively, I support all the previous speakers, what they're saying. I agree with them, I support them. But alternatively, I think the county should be responsible, for retroactively reassessing the value of my property and refund me, the charged fees, and also pay for all the necessary costs
Could you sum up, please?
remedy the defects in order to be in full compliance. Thank you.
Thank you. Thomas Palumbo, to be followed by David McDonald.
Good evening, and thank you for this opportunity to speak to you tonight. As a resident who resides on the ground floor facing the rear garden, I could say that I'm at ground zero for witnessing and putting up with the many dangerous situations that threaten my security, the security of my family, and the security of my neighbors at the Berkeley. I fully support the board's petition to retain positive, secure control of Berkeley's property and take the next step to fully control it by restricting access only to the Berkeley's residents. I've called the Arlington County Police on 4 separate occasions in the 2 years that I've lived in the Berkeley. On August 6, 2014, a vagrant very high on drugs urinated on the wall right outside my window, then passed out on the bench in the garden. On April 18, 2015, at 2:15 a.m., there were 4 drunks drinking and talking loudly in the garden. On April 12, 2016, at 12:15 a.m., 2 men were loitering, drinking, and listening to music. On June 29, 2016, at 8:20 p.m., a woman was smoking pot, then took shelter from the rain in the bushes right outside my window. These are just 4 examples of the dangerous security situation I must deal with every day. Because vagrants, drug users, and drunks feel free to come right up to my window, I cannot even feel comfortable leaving my windows open for fear that someone might break into my apartment. I cannot even have my elderly mother stay with me when she visits for fear of someone breaking into my apartment. I have to put her up in a hotel because I'm afraid of the worst happening. Furthermore, there are significant financial aspects as well. Giving access to the Berkeley's garden to the larger neighborhood is the equivalent of the Berkeley operating in Arlington County Park. In essence, the Berkeley's residents, through their condo fees, are financing Arlington County Park. Nonetheless, security is the overarching issue that is my concern. Security for myself, my family, and my neighbors in the Berkeley. The Berkeley has already had at least 1 break-in, and it's just a matter of time before a major security incident occurs. I believe that the Berkeley should be able to secure the rear of the building and restrict access to the residents of the Berkeley only. Thank you for this opportunity to appeal to you tonight for the sake of the security of my family and for myself and my family. Thank you.
Thank you.
Any questions?
David McDonald, to be followed by David Steele.
Good evening. Thank you for the opportunity for us to speak to you this evening. My name is David McDonald. I've lived at the Berkeley condominium since year 2004. I was one of the first owners. I moved to Arlington from the District of Columbia where I was renting a unit. This is my first purchase as a homeowner. So as you can imagine, it's very important to me. The reason why I want to speak to you tonight is that I live on the first floor of the building. My patio and my bedroom face directly onto the back garden where we've been hearing about all these disturbances. On several occasions, I've heard people late at night, well past 11 p.m., speaking loudly and often at times arguing. On other instances, at least 2 occasions, I've noticed that there's been people who have urinated in the back area, one time urinating against the building, one time back in the garden. So as you can imagine, I was pretty shocked when I first saw those instances. I hadn't seen that before, and I certainly wasn't expecting that in that private area so late at night. So I'm asking you to consider all of our statements here this evening. We hope that we can block off the entrance, at least in the evening hours, for our safety concerns, because I have concerns going forward that this problem could only get worse. And I have safety concerns about the noise and the loitering in the back way in the evening and people urinating against the building. So those are my concerns. Do you have any questions of me as a homeowner?
Thank you.
Thank you very much.
David Steele.
Good evening to the board and the county staff. My name is David Steele. I've been at the Berkeley for 10 years. I actually live on the 7th floor. I'm on the back, but I live pretty high up, so I haven't had nearly as many issues as some of my neighbors had. But I often hear arguing. When I've been around and about the building at night, I've seen people urinating and vomiting around the building, and that's in the front. To be honest, there have been multiple fights. The police come fairly frequently. I mean, that's on record. To be honest with you, I would never walk behind the building at night. It's too narrow. There are too many people back there. There's too much going on. I recommend to my friends they also don't walk back there. I recommend that they walk around the building. It's not any longer, and it basically accomplishes the same thing. And I would like to speak, obviously, a lot of people said it's a little unfair that after 15 years we'd kind of come back. It's one thing to grant the easement, it's another thing to put a financial burden on the owners to create that easement. I can't see why, after all this time, we would be asked to do that. I understand it's in the interest of the county to keep green spaces and walking spaces and things like that, but I think it's pretty clear that this particular area, it doesn't really fall into that category. It's not particularly useful for access. It doesn't shorten anyone's route. And it's an enormous inconvenience and property lowering to a lot of the people who live around the Berkeley. Thank you.
Thank you. Questions or comments from the board?
Madam Chair?
Ms. Malice.
I want to thank all the members of all the residents of the condominium that came and spoke to us, and I am very sympathetic with the difficult conditions that they're living under. But I want to clarify what I understand our role is. We are not the county board. We do not interact with the site plan. I'm sure your attorney has explained to you that you have a site plan. It has conditions. The term of a site plan usually runs 30 years, maybe for this one. I'm not sure what the term is, or in perpetuity. Perpetuity? So it's a very different kind of a situation. I understand our role on the Board of Zoning Appeals to be very narrow. We are looking at the law. We really are not looking at conditions. That is really for the county board to look at when they look at site plans. And so my understanding of what I am to do is to determine if the zoning administrator made an error in ruling on the law. And all of these situations, I think, need to be addressed, but they possibly need to be addressed in a different forum than this one. That's my opinion, and I'll look to see what our colleagues do. But love to talk to you some more, but maybe my colleagues would also like to weigh in on this question of what our role is tonight.
Other comments? Questions? The county attorney care to comment?
Yes, that is our position. The site plans are set by the board, and when it's created, it's a legislative function of the board. The site plan itself is an ordinance, and the county board is the only entity with the power to amend or change the site plan. The zoning administrator has no authority to amend the site plan, and I've cited cases to that effect.
Thank you. Mr. Rowan.
Thank you. So I want to associate myself with Ms. Malice's remarks. I think I'm in the same spot. I mean, the testimony and the evidence presented in this case is, I think, super clear. There's no doubt in my mind that not only is the nighttime activity behind the Berkeley condominium burdensome, but it is unusually burdensome for Arlington. I've lived for 18 years in the Clarendon Courthouse neighborhood of Arlington. I used to be the neighborhood association president. I lived on the 8th floor of a condominium on Clarendon Boulevard. I currently live 2 blocks away from Clarendon Boulevard. In my neighborhood where I live now, we have public access easements. We have little park-like areas with benches that may be the very same make and model as the ones that are behind the Berkeley. So I feel like the conditions that the neighbors have described are very familiar in terms of the milieu, and the burdensomeness that I think has been very clearly demonstrated in the evidence that has been presented to us, to my mind, far exceeds the norm, even the norm about which other neighbors routinely complain. You know, in my neighborhood, we get complaints. In my household, we get complaints about drunk people screaming and yelling and walking behind our house and so forth. And the extent that the residents of the Berkeley are clearly enduring is way out of the norm for Arlington. And so I'm extremely sympathetic, but I think I agree with Ms. Malice that what seems to me to be a really sensible outcome, which is closing the gate at 10 o'clock, is not one in my power to grant as a member of the Board of Zoning Appeals. And so I have to choose among other options based on the way that this has been presented. So, so that's sort of my orientation, but I do have some additional questions. I'd like to ask if the easement had been granted at the appropriate time. Let's imagine that everything had been done correctly in 2004, and then there was a complaint that there was a lock on the gate and a sign that said no trespassing after 10 p.m. What would the next step for county enforcement officials be at that point?
At that point, it wouldn't be a zoning violation because the site plan would have been complied with. It would have been a violation of the actual easement.
And so what would be the county's remedy?
I believe we would just get an injunction.
Okay. So you do not, so I'd ask the zoning administrator, have you made an interpretation that as to whether or not the site plan condition in question provides a substantive requirement to continue to allow access? Or is your interpretation that literally it's the filing of the paper that grants this injunctive right is the only site plan condition? So let me put it another way. It seems to me that the testimony that we've heard tonight, that the reality of what's really at stake is, can members of the public freely walk through here or not? And so what I'm wondering is it your view that this site plan condition as the county board enacted it is really limited just to filing the paper at the courthouse in terms of the easement, or does it have any substantive component to actually allowing the access?
I think it's both. And I think I went back and looked at the documents associated with it, and in the initial staff report, there was mention in describing the design of the site plan that there was to be a walkway and that the intent was for it to be available for public use. And this condition actually was added later, I assume, to make clear that it was required and to assure that it happened and that it remained open to the public. So there was an intent on requiring the easement be granted so that there wouldn't be any confusion or doubt about what the space was for and who was entitled and supposed to be able to use it.
And in fact, the complaint, as you stated to my initial question, the complaint was not somebody who was flipping through court records and said, I don't see the easement here. It was somebody who noticed that they were trying to get access and couldn't get access.
They were concerned that it could be locked. It was now there's a gate here with the ability to be locked. And does this mean that I'm not in the future going to be able to continue to pass through? So it was.
So I have a couple questions for Mr. Lawson, but one of them is also for you. Do you agree, and I'm going to ask Mr. Lawson the same question, do you agree that the C of O was issued in error, that it should not have been issued?
I agree that we should have done our homework and made sure that that all of the requirements had been satisfied.
That the reality of the situation, that was notwithstanding whatever statements were on the C of O, that in fact all conditions had not been complied with.
Yes.
All right. So I was going to pose the same question to Mr. Lawson, but he's walked to the back of the room. So I'll ask him in a moment. But I do have another question, which is there is a provision in the state law. I'm going to try and find it here. Oh, yeah. 15.2-2311 says the 60-day limitation period shall not apply in any case where, actually, I do really want to ask Mr. Lawson this question before I get to the next one. So, Mr. Lawson, do you also agree that in 2004 the C of O was in fact at the moment it was issued incorrect in saying that the conditions had been met because they actually hadn't?
No, sir. We have changed our position in good faith reliance on the action of the zoning administrator, and the only time the 60-day limitation does not apply is to correct a clerical error. And a clerical error is something like they have the wrong date or we worded it wrong. It's not, a clerical error cannot be Well, we analyzed it, and we decided it complied with zoning, but oops, sorry, it doesn't comply with zoning. That's not a clerical error. And I think under 15.2, 2311C, just like the county attorney said in that other case, the zoning administrator is powerless to issue this zoning violation.
Do you have any, can you point to any case law that defines what clerical error is? Or are you just going in the plain reading? Do you know if any Virginia court has interpreted what clerical error means?
To my knowledge, it has not.
Okay. And the other question I wanted to ask you was, do you know if I tried to read through the cases and did not, I don't think I saw this in the cases that were cited to us, but are there any Virginia cases that you know of where where a certificate of occupancy was referred to by a court as demonstrating the thing decided?
Not to my knowledge.
Okay.
We've had 2 appeals that we have filed in the past where upon analysis of the CO, the violation notice was withdrawn.
Thank you.
That's 2 times in Arlington it has happened, but I'm not aware of a Supreme Court case that says a CO is a decision that there are no zoning violations.
Thank you.
Other questions for Mr.
Actually,
Lawson or the staff?
Madam Chair, if I could just do one more on the exact same thread.
Quickly.
And I wanted to ask then the zoning administrator, the county attorney, do you agree with Mr. Lawson that this is not a clerical error? Or have you thought about using the clerical error remedy under 2311?
We don't agree that 2311C applies in this case at all, so we don't consider this a clerical error. I mean, that's for when the zoning administrator makes a mistake, but amending a site plan condition is beyond her power. That's not a mistake she can even make.
No, my point is, it seems to me that the zoning administrator made a mistake in 2004 by issuing the C of O, and that that C of O was plainly incorrect in saying that the conditions had been met, because we all know as a matter of judicial notice, public record, there's no easement filed.
And
So-
we're not trying to withdraw the CO. We're just saying that they need to comply with the site plan condition.
Right. Okay. Thank you.
Other questions, comments?
Quick question.
Mr. Smith.
So I heard what Ms. Vaughn said with respect to how we got here, how it started, Mr. Owen's initial question. And I guess I want it repeated, that it was that the gate could be locked and thus deny access?
There was concern that since a gate was installed, that there might be an attempt to close off access that before had been unfettered. And so we were asked to look into it.
Okay. But without a lock, there is access, unfettered. Okay.
Other comments? Ms. Niles?
Well, I guess I would like to come to some conclusion, as to where I stand on this, and sort of lay out a framework for maybe the condominium members. I think the issue here is, let's say for the moment that the easement had been properly recorded, you would still have a problem today, as the condition, that you properly recorded easement allowing people to come through your backyard would still result in the same situation you have today. And so you would be facing, looking for some relief from the county board in terms of a site plan amendment. So in terms of correcting your situation, your path would be to the county board in any case, whether or not the easement has been correctly filed. I think your attorney and some of you have made a point a number of times about the costs incurred in either seeking an amendment or seeking an easement or seeking an amendment to the site plan. And that's something that I guess we could recommend as a board, that there be some consideration given to waiving that fee given the circumstances. But in terms of the plain reading, of how I see what has transpired, it was clearly the intent of the county board that there be public access. the method was an easement. The fact that the easement wasn't correctly implemented, I don't think changes the intent that the county board had, that there be public access. So I'm not sure that I see that the zoning administrator acted in error in that very narrow technical sense. But I think you all ought to be seeking the wider remedy with the county board.
Any other comments or questions? Okay. Do I hear a motion?
I would be happy to move this.
Thank you.
The County Board of Zoning Appeals make the findings in the attached resolution and determine that the violation notice stating that the condominium was in violation of Site Plan 352, condition number 64, was properly issued. However, if I may add to this motion, I would recommend that the county, I would strongly recommend, the board would strongly recommend that the county consider waiving fees that would be involved in correcting the situation.
Is there a second? I will second. Discussion?
Well, Madam Chair, I hope it's become clear that in the absence of a lock, I see an easement. I think there's open access. There aren't any signs that restrict. I don't think they have to put up a sign that says public welcome. So I find that the zoning administrator has erred in issuing a determination that there's a violation of the site plan.
Comments?
Madam Chair, I think the zoning administrator was correct, and moreover, it is my personal belief that the county board ought to work with its constituents to address the situation, probably through an amendment to the site plan. But I am not comfortable advising the county board as the BZA because we're not an advisory body. And so I cannot vote for the motion as it has been made and seconded because I don't think it's correct for the Board of Zoning Appeals to advise the county board. Even though I agree with the advice, I don't think as the board it's something we should do. So, so after waiting perhaps to see where Mr. Melnick is, I might have a motion.
Mr. Melnick?
As I stated before, I have an interest as, a fiduciary property owner, one townhouse away from where all this is happening. And so that's the reason, I have my participation has been, more just listening, because, I wouldn't ever want to be seen as favoring one side or the other, having any kind of personal interest, any vested interest, because there are tenants of the trust in there, which is, money making for the trust. So that's my position. So I can't really comment on one side or the other. I don't want to sway the way the board goes.
I apologize, Mr. Melnick. I forgot that you had recused. My apologies. So I would make a motion to delete.
Wait, well, we have an emotion.
I would offer an amendment to the motion.
Substitute motion.
Whatever you'd like. We could. What's your pleasure, Madam Chair?
I mean, as the maker of the motion and the seconder, we can withdraw our motion.
I would
or
ask
you can make a substitute
I'd ask
motion.
unanimous consent to amend the main motion to delete the surplusage that Ms. Malice had added and stick with the resolution as printed in our materials.
No objection.
I would agree with that. Although I do agree that the relief should be provided.
Yes.
But I also agree that it's not our job to do that. Okay, so the motion is as presented in the staff report?
Yes, to uphold the zoning administrator as presented in the staff report is my understanding of our motion.
Okay, I'll second that also, just to make sure we have it covered. Let's have a vote.
I'm still the maker of the motion. There was unanimous consent to modify the motion, so.
Well, I'll abstain from the request for unanimous consent. I don't think it's necessary. If the maker and the seconder agree to withdraw, then you can substitute.
We're good. We're good?
You're good.
Yes.
All those in favor of the motion?
Aye.
Aye. Opposed?
No.
3, 1, 1 abstention. Thank you. Next case.
Next case is V-11217-16-APP-1, an appeal by Maura Quinn and David Lemick of the zoning administrator's approval of a permit to build a 1.5-story garage at the premises known as 720 North Frederick Street in the R6 zoning district. Staff is not making a formal presentation, but is recommending that the board make findings and determine that the permit for the garage was properly issued, and we'll take any questions you have at this time.
Could those, excuse me, as those of you who are leaving could do as quickly and quietly as possible? Thank you. Questions for staff? We'll hear from the applicant, please.
I'm sorry. Hi. Good evening. My name is Dave Lemick, and thank you for the opportunity to speak tonight. You may recall the last time we were here in April was to discuss a variance for a neighbor's house that they had purchased and had not yet moved into. Along with the house renovation, there was also going to be a 1.5-story garage built 1 foot from our front yard property line. After we spoke at the board meeting and we were determining what to do to have the zoning administrator's decision reconsidered prior to construction beginning, one of the board members, after we were done talking, had said that it would be preferable if the two neighbors could get together, sit down, and work this out amicably. And we agree. In fact, prior to the construction and prior to that zoning meeting, Maura and I sat down with Brad in our kitchen to let him know our concerns and to try to come up with an alternative placement so that Brad and Susan could have their garage and we could keep our front yard without the garage next to it. We even made little scale cutouts and a map with some silhouettes to move around their property to show that there indeed were alternatives. So I just want to assure the board that that did happen. Brad and Susan were not interested in any alternatives, nor were they interested in talking with us. So that's why we're here tonight, trying to get a resolution. So with that, I'd like to introduce myself. I'd like to introduce my wife, Maura, who will lay out our reasoning for having you reconsider the permitting. Thank you.
Thanks, everyone. Good evening. So, as you can see, there's the 1.5-story garage has already, the construction has already started on it, although we filed our appeal within the time frame that was required. So, from our perspective, the zoning code is in place to protect the rights of everyone, not just the property owners, but the community itself. And the state actually says it's to promote the health, safety, and general welfare of the public, including to facilitate the creation of convenient, attractive, and a harmonious community. And we think in this case that did not happen. So the zoning administrator looked at one provision in the code, which is talking about setbacks on a corner lot. But we think there are some other provisions that the board should consider before making a determination. The first one that the zoning administrator did not consider is section 3.2.6A2B. And that provision talks about the placement of a building on the lot. And it says no structure shall be located closer to the side or rear lot lines than as follows. And B in that provision says for all one-family dwellings and their accessory structures, the side lots setback should be 10 feet, provided that one side yard may be reduced to 8 feet. So a accessory building is a structure. The provision that the zoning administrator relied on is for all accessory buildings in our districts. So those are co-equal provisions that conflict with each other. And our position is that when there's a conflict in the actual zoning ordinance, that the board should look at the most restrictive of the two different provisions. The next one that the county did not consider was section 3.2.5A, which talks about, it's the coverage provision. It talks about what coverage can be used when you're putting different kinds of structures on a building. And there, it specifically talks about a detached garage in the rear yard. And the county says, well, this is a bonus provision, so it doesn't apply. But that's not why we bring this to your attention. We bring it to your attention because of the intent of the zoning ordinance itself, and that is, in Arlington County, for detached garages to be in the rear yard. So when you drive around Arlington County, you don't see garages abutting the front yards of neighbors' properties, and that's because the intent of the ordinance is to weigh the rights and the interests of the different parties, and not to have that kind of encumbrance on someone's front property or front yard. Another thing that we'd like to point out is we've lived in this home, our home, for 15 years. The building, or our house and the one next door were built over 50 years ago. So the house next door to ours that now has the 1.5 story garage, which is 18 feet tall, and we actually provided some different pictures that show what it looks like, and I think you all have those from standing in our front yard and what that building looks like. So the address of that house is on Frederick Street. Its front door is there. Its mailbox is there. It is aligned with all the other homes on Frederick Street. That is the front of the property. And we understand that there's different dimensions that the county relied on to say, hey, what is or is not a front yard. But in this case, the property owners are saying, basically, we get to have 2 front yards. They've completely gutted that house, and they didn't change the location of that front yard. The front yard is now not on Bluemont Drive. They've kept it on Frederick Street. They've expanded a front porch on it, and they've put the burden and are using what they call the side yard as the rear yard and putting that structure in our front yard. And one of the reasons, even when you look at what the corner lot provisions talk about, which says a 1-foot setback for a side yard and a 10-foot setback for a rear yard, those are in place to protect the interests of the neighbors. So if these properties were aligned, and you can see how the street curves, and you can see from one of the overhead pictures we've previously provided to you, that if the properties had aligned and our side yard was aligned with their side yard, if it was a grid, it would be fine. But that's not the case here. The case here is that their side yard aligns with our front yard, and they are putting a building that normally is not allowed under the zoning ordinance, because you don't put these kinds of structures and abutting other people's front yards. And the last thing we'd like you to consider is how this adversely affects our property. So we previously provided to you pictures of a drain that's on their property. For many years, their property had a sump pump on it. The properties in the neighborhood go down kind of V-shape, so their property is sloped down, as are the other houses along Frederick Street. And when it rains heavily, there's a stream that comes down and goes into the grate that's on their property. And we actually had the county help us put in a rain garden to help us with that kind of flooding issue. So now they've placed their garage 1 foot from the property line, and it hasn't rained hard since this has happened. But when it does, all of that water is going to back up into our other neighbor's yard and come into ours. So we'd ask you to consider all of those different points. And again, when there's a conflict between the different zoning ordinances, those provisions, the more restrictive applies. And we would ask you to take that into consideration. And if you have any questions, we'd be happy to take them.
Thank you. Questions for the applicant?
Thank you.
Thank you.
Madam Chair?
Ms. Malice.
I have questions for staff on this. We have many corner lots in Arlington. Are you aware of other lots in Arlington that have this condition? I mean, I guess I'm kind of putting you on the spot, but is it likely that there are other lots that have this condition?
I'm sorry, can you clarify what you mean by this condition? Are you referring to the lot lines, the front lot lines not aligning with one another?
The garage being effectively in what appears, let's see how to put it, the garage being adjacent to the front yard of another house.
It would be hard to say without actually.
Situation truly the only one of kind in Arlington? I would imagine that we have many cases like this. I just am not aware of them. Where you have a garage that is next in the front, because it's around the corner, it's going to be in the front yard of somebody's house, next to somebody's front yard.
I think this is, I don't know if this is the only situation like this. I think what we do see here is a unique situation because what we see is the lot lines along North Bluemont Street aren't aligned. I don't know if there are other instances like that.
Describe more what you mean when you say they're not aligned.
Actually, if we can, I think we may have one of the previous slides that gives us the aerial view. So the way that the road curves there at the property at 720 North Frederick Street, that lot line closest to North Bluemont Drive extends further than the adjacent property's front lot line.
I see what you mean.
Other questions or comments?
Yeah, Madam Chair.
Mr. Owen.
I guess first of all, I want to thank the appellants for a very thorough and thoughtful presentation, which I found very helpful to read. There is one particular argument that they make that I'm still confused on, which is why is this structure not prohibited under 3.2.6A2B, which appears on page 3-10 of the zoning ordinance?
Because the following provision applies. It's garage is considered an accessory building. So if you go to the next C, that would be the provision.
Yes, I'm willing to agree that C applies, but I'm wondering why B does not apply.
I would say that the more specific provision applies. So I always get confused. The structure building, it's a building and a structure, but the building.
A building is an enclosed structure.
Right.
All buildings are structures, but
yes.
Not all structures are buildings.
Yes, that's the one I was.
So it's your assertion that accessory structures may not be this close.
But buildings
But
may.
an accessory building may be this close. And so they're not in conflict.
No.
Because once you enclose it, it's okay. That's not an argument I thought of on my own. So thank you for explaining it.
Sure.
Other questions of staff? We have a speaker, Mark Freelander.
I am Mark Friedlander, and I'm the attorney for the owners of the house. As you can see from the layout, this is where the driveway was. The garage is being built at the end of the driveway. The whole house has been renovated, but the existing house that was there and the footprint has not been changed. That is the same house. It was made into a one level because the people have a December marriage. They're not here because they're on their honeymoon. They redesigned and built this house to move here and to age in place. The garage, as far as we know, is by right. It complied with every requirement. They actually had made a mistake when they first began. They thought it was going to be a two-story garage, not permitted, and they changed it and complied with every requirement, and that we would ask that the ruling or the issuance of the permit by the staff be affirmed.
Questions for Mr. Friedlander? Thank you.
Oh, I thought you asked me.
Further discussion? Mr. Smith.
I want to join Mr. Owen in acknowledging the work of the appellants. Obviously, a lawyer with a sharp eye, but I think Mr. Friedlander put it best. It's really a by right kind of an option, and for that reason, I'd move that the Board of Zoning Appeals affirm and uphold the zoning administrator's issuance of the building permit at 720 Frederick Street.
Moved by Mr. Smith, seconded by Mr. Melnick. Discussion? Mr. Owen.
Go ahead, Mr. Melnick.
Okay. So I too would like to commend the appellants, on being here and voicing their views. But as was said previously in the meeting, our job here is to follow the law. And there's a lot of rules that apply here that have been examined and looked at. But it does seem clear to me, having heard from the Board of Zoning Appeals or the zoning administrator, that we just have to look at the wording of the laws that apply, and that's the reason I'm going to vote in favor of the motion.
Mr. Owen.
Thank you, Madam Chair. I agree with my colleagues about the nature of our determination. I will add that I do not agree with all but one of the arguments that were made by the appellants. But the one argument I agree with, I find dispositive. I do agree, based on my reading, even after having heard the zoning administrator's explanation, I do think that 2B and 2C are in conflict. I note that in 2C, 2C2, the words provided, however, are used. So in writing this section of the code, the county board was clearly aware that it could use language explicitly creating an exception. I think the plain meaning of the two provisions are in conflict. I appreciate that reasonable legal minds and non-legal minds could differ on the specific controlling for the general, but I don't see it in this case. I think the plainer meaning is that there's two provisions that are simply in conflict, and reading out the conflict of the plain meaning is something I'm not totally comfortable with, so I'm going to oppose the motion. But again, I would like to say that I do support the zoning administrator's arguments on the rest of it. I do think that the actual front yard and the legal front yard are different, and that basically, controls in this situation. But even the side yard is controlled by 2B, and so therefore I'm opposing the motion.
Thank you. Other comments? We have a motion on the floor. All those in favor?
Aye.
Opposed?
No.
The motion is approved, 4-1. Thank you. Call the next case, please.
V-10888-14-UP-5 is a use permit request to permit a setback of 10 feet to the eve of a new third-floor addition from the 21st Road North right-of-way instead of 25 feet as required, and to permit a building in excess of 2.5 stories within 25 feet of a street right-of-way. Staff recommendation is to defer the use permit request to the February 2017 BZA hearing.
We have a motion.
I'll make a motion.
Is there a second? Moved by Mr. Melnick, seconded by Mr. Smith for deferral to the February zone BZA meeting. All those in favor?
Aye.
Thank you. Next case.
V-11195-16-UP-1 is a use permit request to permit a setback of 25.4 feet to the wall from the rear property line instead of 50 feet as required, 8.3 feet to the wall from the left side property line instead of 16 feet as required, and 11.4 feet to the wall from the right side property line instead of 20 feet as required. Staff recommendation is to defer the subject use permit to the May 2017 Board of Zoning Appeals hearing.
Thank you. Motion?
I'll say move on this one. For a deferral to the May 2017 Board of Zoning Appeals meeting.
Second?
Moved by Mr. Melnick, seconded by Ms. Malice to defer to the May meeting. All those in favor?
Aye.
Thank you. The next case, and we have some comments from the board prior to calling the case.
Madam Chair?
Mr. Owen.
Thank you, Madam Chair. As I stated at the last meeting with regard to V11198-16-VA-1, due to my acquaintance with the applicants, I'm going to recuse myself from this matter and vote present.
Thank you. Ms. Malice.
I would like to disclose that I am personally acquainted with the applicant, Ms. Brown. We served on the Planning Commission for a number of years and also worked on other projects. That said, I believe I can fairly decide this case and will hear this item. Thank you.
Thank you. We hear from the applicant, please.
Would you like for me to call the
Sorry.
case?
Sorry, Barnes. Staff, please.
V-11198-16-VA-1 is a variance request to increase the allowable main building footprint to 3,173 square feet instead of 2,772 square feet as required. This is for a new screen porch and bathroom addition. The staff recommendation is to adopt the attached resolution denying the request.
Thank you. Questions for staff? Mr. Lawson.
Madam Chairman, thank you. For the record, my name is Barnes Lawson, Jr. I represent the applicant. I think the best way to do this is to hand out a variance for coverage, which had a favorable staff report, and kind of compare the two. So if I may. If the board would be kind enough to go to the second page at the bottom paragraph, and I'm going to kind of go through this, and again, we have a favorable staff report on this other application. I want to show you how these cases are similar, and I just don't understand why one has a negative recommendation, ours, and this past one had a favorable. As we go through it, first thing that they say is that the applicant purchased this property prior to the adoption of the main building footprint cap regulations. My client did not purchase it before that, but the house was built before there even existed a zoning ordinance. The lot has some degree of hardship because it is nearly 2.5 times larger than the required lot area for the R6 district, and the existing home already exceeds the main building cap. Same thing here, same exact situation. Let's see, number 3, it's the largest such property in the vicinity. Yep, same thing with our property. Flipping over to page 3, where the test is the hardship unique, and what they said in this other staff report is the properties in vicinity do not have the same characteristics as this parcel. That's true here. When you look at the staff report where it has our tax map, you can see that. The only by right option for expansion on this lot would be to build an addition above the main building footprint. Same thing here. We go down to the next test. Did the applicant cause the hardship? Said the applicant did not cause a hardship on this particular lot because a change to the main building footprint cap regulation of the zoning district only became applicable to the property in 2005. Same thing here with this property. Would the variance, if granted, be detrimental in any way to adjacent properties? We go down and we have approval of the variance would not be detrimental to adjacent properties. Same thing here. Numerous properties in the vicinity have additions that are similar in size to the proposal. Same situation we have. The existing home and the proposed addition would be appropriate for the size of the lot and would not be placed close to any side property line. Same thing in our case. And then comments from neighbors. The applicant has submitted 6 signatures from neighbors in support, and we have neighbors in support as well. I want to talk for just a minute, Madam Chairman, and take a little bit of issue with you when you were talking about the Cochran court case. And you had said there was a court case that says that all use of the property has to be precluded, and that's not accurate. The General Assembly legislatively overturned the Cochran case. And what the staff says is you should deny this because there's already a reasonable use. That's not the standard. The code does not say that if there is a reasonable use, don't grant a variance. What the code says, it says a variance shall, word shall, be granted if the evidence shows that the strict application of the ordinance would unreasonably restrict the use of the property. So is the strict terms of the ordinance unreasonably restricting the use of the property? That's the test, and that's what you all have to evaluate. I've been fighting this fight ever since the legislation got passed. Frankly, I'm frustrated. And so I went to my delegate, Delegate Patrick Hope, and he's written a letter that I'm going to share with you all. And he agrees with me, and he does not agree with the staff. And hopefully this will put to rest this issue over what kind of a hardship justifies a variance. I'll give this to you. And I took some photos that I'm going to, you're going to see other photos, but I wanted to show you where it is on the house we want to put these 2 additions. And I took some pictures, and I have the house footprint, and you all can see that. And if that helps you, I'll share this with you.
Thank you. For the record, I read the script.
I don't know if that helps you any, but
Questions for Mr. Lawson? Okay. Ms. Mells.
I would like some clarification from staff on report. I'm a little confused as to HLRB's actions. So the design review committee found it inappropriate, but the full HLRB voted to support it? I'm reading on page 2. The last 2 sentences, am I reading that wrong, of the proposed changes? To be inappropriate in the design review committee found it inappropriate, but HLRB has provided a statement of support?
The comment in that paragraph referring to the design review committee was in regards to the by right option, which would be available under the zoning ordinance for this property with regards to a screened porch.
And the HLRB provided a statement of the non-by right option.
That's correct. Mm-hmm.
Other questions? Okay. We have quite a few speakers, so I'll call 2 at a time, beginning with the 2 applicants, Ginger Brown to be followed by Kim Brown.
Hi, good evening. Thank you for giving me the chance to speak. My name is Ginger Brown, and my husband and I purchased the house known as Broadview as our forever home 6 months ago. It is a wonderfully quirky house. It has a tower, amazing porches, and even though the grounds are a fraction of what they used to be, it has the potential for the garden of a lifetime. But the house needs a lot of love, lots of it. So we are desperately trying to invest in this iconic county historic asset using the strictest historic standards. We take our responsibility as stewards of this home very seriously. We've gone through the HLRB process, giving in to all of their requests. For example, we skipped building a garage so that the public would have a view from the street. We won't screen any portion of the 665 square feet of porches, even though it would be much cheaper and easier for us to do than what we have proposed. The list goes on. We have already been through the equivalent of what is a site plan process for single-family homes. We have received our certificate of appropriateness and the support of the HLRB. We've also begun the 3-part application to become eligible for the Virginia State Historic Tax Credit Program and the National Historic Registry. That program is even more restrictive than the county because it looks at the interior of the historic house. The most historic walls can't be touched or we lose the entirety of the state funding. Frankly, we aren't interested in ripping apart the historic walls anyway. That's not why we bought the house. And it would be a hardship to force us to destroy the historic fabric of the house if we went with the strictest zoning code interpretation. Our request is neither trivial nor superfluous. It is necessary. It will make or break this project. We are caught between one set of staff saying we absolutely can't maximize the efficiency of the house and another saying that is the most important part of this project is to maximize the efficiency of the footprint of the house. We are caught between a rock and a hard place. Thank you.
Thank you. Ken Brown, to be followed by Rob Schutler.
Thanks very much. So I'm a practicing attorney, which is important because it means that I know to defer to my counsel on all of the legalities of this situation. I'm also a practicing husband, which means I know to defer to my wife on really
everything else.
Virtually everything else. But I do have a perspective on this, and I just want to make 2 points that I think are important. The first one is to build on what Ginger said. You know, it is the stated policy of Arlington County to promote the purchase and, preservation of and investment in houses just like this one. Without a variance, it is not financially feasible to do that. The only other way to do it is, as Ginger said, to gut the inside of this incredible historic home, and we very much do not want to do that. That was not why we bought the house. The other thing I wanted to share is that when I was a kid, both of my parents served on our local zoning board of appeals, and I remember very distinctly, especially my dad coming home and bragging about how the board had worked with, community members to find solutions that worked for everybody. And we are very grateful to be before a board that has the ability to do that, to use discretion, and frankly, to use common sense. We recognize that staff is sometimes sitting there with their hands tied where they've got a standard and they feel like they can't deviate from it, but we're pleased to be before a board that can. We very much appreciate your attention to this matter, and we hope for a favorable resolution. Thank you so much.
Thank you. Rob Schutler, to be followed by Steve Cole.
Hi, for the record, I'm Rob Schutler. I'm the architect for the project. I want to thank you for your service. I've been on the boards like these, and I know it's often thankless. I wholeheartedly support the zoning restriction that limits the bulk of a house on a given site. As an architect creating unique custom homes, I want to see McMansions even less than you do. In fact, years ago, I contributed to the zoning committee that effectively downzoned the residential zoning in Arlington from the 60% coverage we used to have. But tonight I'm here to state that the case of Broadview is diametrically opposite of what the statute was developed for. Here we have a pre-existing mansion, not a McMansion, but a real thing, that has had an R6 zone applied to it, even though it is twice the land that its neighbors have. This house predates the 1950 zoning ordinance by 70 years. It is clear that in no way does granting an exception create a precedent that other applicants could exploit. This is clearly a unique case. Our discussions with the zoning staff centered on the definition of hardship. They could not see the term hardship applied to a house of this size. They probably reasoned that with this much square footage, it could accommodate any need, but I believe they may have missed the point. Owning a historic property is a hardship, and I can prove it. Grand houses once lined many of Arlington's streets. Let's just focus on Lee Highway as an example. There are still a couple of the old houses between Lexington and Route 66. Honeysuckle Hill has recently been subdivided. It's not likely to survive. There's a grand house tucked 2 houses up on Jefferson Street above Joe's Pizza and Pasta. In the 1930s, its lawn stretched all the way to Lee Highway. It's pretty well hidden now. The Grand Victorian...
Could you sum up, please?
Sorry?
Would you sum up, please? Your time is up.
To sum up, I would say that owning a historic property is in itself a hardship, and the fact that there are so few of them left proves it. And that I believe that to remain in this community, this house needs unequivocal support from the board and the brave family that has taken on this project. Thank you very much.
Thank you. Steve Cole, to be followed by Christina Hedrick.
Does it start when I start talking, or does it start when I raise the...
It started 7 seconds ago. We'll start you again. Let me start again, please. Thank you.
Members of the
Mr.
Board of
Cole.
Zoning Appeals, thank you for the opportunity to speak on behalf of the Browns, the owners of Broadview. As you know, I served alongside Mrs. Brown on the Planning Commission. This is a classic case of the perfect being the enemy of the good. The Browns, in my view, are providing considerable benefit to the community while at the same time pursuing their own dream, living in and modernizing an important Arlington historic home. Their action benefits the community by preserving Broadview, which provides today's Arlingtonians with a clear link to Arlington's past. Broadview was the historic home of the Lacey family, one of Arlington's most important and prominent families. The continued presence of Broadview is a reminder of Arlington's roots. In addition, the Browns have worked assiduously to meet state and local preservation requirements. It's worth noting that maintaining a historic home like this one presents requires a significant investment. It's this very reason, in part, that Reeves land remains unsold. And importantly, it's the very reason that the Shepherd House in Glen Carlin, the house which Barnes referred to, was demolished. The expense to maintain and restore it was too much. The central question here is laid out by staff as one of lot coverage and hardship. Should a variance be granted to allow construction of a small addition and enclosed porch that would result in the home's footprint to exceed the limit set in the zoning ordinance by 401 square feet? This is exactly the kind of variance granted to the owners of the Shepherd House by the County Board when it approved their request. A couple of numbers are instructive. Staff supported the approval of the Shepherd House application, concluding a footprint of 4,656 square feet, 56 square feet, or about 19.4% lot coverage would be acceptable given the 24,000 square foot lot. Note this is an increase of 40% above the ordinance allowed maximum lot coverage, maximum footprint rather. With respect to Broadview, the Browns are seeking to increase the lot coverage by 401 square feet. This represents an increase of only 15% above the footprint maximum. Moreover, lot coverage would only be 24.7% compared to the allowable 46% on a 6,000 square foot standard lot. It's hard to argue that the Browns' request represents an unreasonable ask. Beyond this is the question of hardship. Very quickly, I just want to point out that one of the major additions that they're making is to add 2 bathrooms. In this day and age, a house like this with as many people that will live in it as this family has, to say that bathrooms are not, the lack of bathrooms is not a hardship, is to misunderstand what the nature of the request is. Thanks for your time.
Thank you. Christina Hedrick, to be followed by Sandy Chasron.
Hello, I'm Christina Hedrick, and I'm a resident of Waycroft Woodlawn, and I would love to be the Browns' neighbor. I'm here tonight to speak in support of their application for this variance. They've requested the variance in order to proceed with a beautiful, thoughtful renovation and a preservation of one of my neighborhood's most historic and most important properties. They believe their plan, by not moving around some historic internal walls and instead having a modest expansion of the footprint, will be the best plan to allow them to qualify for state historic preservation tax credits as part of their investment in preserving this important landmark. I've been a homeowner in Waycroft Woodlawn for 2 years. The preservation of irreplaceable historic features is and should be a key community goal for development in Arlington County. I would like to see you consider the concerns of historic preservation in your decision tonight. It is striking to me that the Historic Affairs and Landmark Review Board approves of these plans, but now they are tangled up in the variance process. The regulations that have been applied were designed to try to curb McMansions on much smaller lots, properties that are half the size of this lot, and they should not be applied with a one-size-fits-all blindness that could result in a negative outcome for the historic renovation and preservation of Broadview. I myself have renovated 2 historic properties that were on the National Register of Historic Places. I understand the amount of tediousness and difficulty with doing a project of this size. I've reviewed the request for a variance, and I find it to be very, very reasonable. The modest changes to the footprints allow the Browns to preserve historic walls, to make a dangerous staircase much safer, and to have 2 updated bathrooms for a family of 4 upstairs. In Arlington, it seems, with all the newer houses, there's a bathroom for everyone, even the dog. I would find a request to have 2 updated bathrooms upstairs to be very, very reasonable. If you do not approve the variance tonight, I'm really concerned that the resulting loss of this property or it being turned over into the hands of somebody else could really be a loss for my neighborhood. I would greatly encourage you to entrust this property to the Browns and approve their variance.
Thank you. Sandy Chesron, to be followed by Greg Sizemore.
Members of the BZA, thank you for giving me an opportunity to support the preservation of Broadview. As you know, after investing a lot of staff time, the county board voted unanimously to designate Broadview as a local historic district. While preserving the house, the historic record states that the designation was also intended to include additions that allow new and old architectural fabric to coexist successfully, as preservation recognizes that times change and properties evolve. Today we have a family who has faithfully tried to honor the historic designation by investing in a good architect and a good landscape architect to develop the drawings, which HLARB agrees are extremely sensitive to preservation, yet allow the house to evolve. The small 87 square foot footprint in question would allow improved circulation and accommodation of parents or others who might require handicapped access to bathrooms. The improvements are, for the house and the neighborhoods, very positive, and with this, HLARB and all the neighbors agree. Yet here we all are, with the same purpose of preserving the house. All agree that the renovation would strengthen the house for decades to come. Only being debated is a zoning issue that was never intended to discourage preservation, but rather was a tool to discourage McMansions through restricting the footprint of new houses, not historic ones. The staff's recommendation of denial puts the house in jeopardy. That's just a simple fact. As a preservationist, I strongly urge you to protect this house and allow the Browns to proceed with their well-conceived restoration and to save Broadview for their family, their neighborhood, and all of Arlington. Thank you.
Thank you. Greg Sizemore, to be followed by Michael Leventhal.
Good evening. Thank you for allowing me to speak on behalf of Ken and Ginger. My name is Greg Sizemore. I moved here with my family just in the middle of this year in June, and I live directly across the street from that stunning home. It was one of the reasons that we actually decided to build in this area, because we felt like you don't get too many chances in life to live around something that has historic. And the more you research that, looking on the internet and trying to figure out, okay, what is this place all about? And then when we met Ken and Ginger and they showed me around the property and they began to speak about the things that they'd like to do to the home, what they wanted to preserve in the home, and all of those types of things, it resonated well. One of the things that I would like to just point out to everyone here tonight is all along the way, as a neighbor across the street, they've been very thoughtful. The landscaping that they're going to undertake, the architectural changes and modifications have all been very, very tastefully done. We collectively have signed off on those things. My wife has signed, she was the first person on the list to say that's incredible. We'll also be a beneficiary, if I may point out the obvious, of the outdoor enhancements that we're talking about. The landscaping is going to be a big key, and the screen porch on the back side will be something that, for a new community, there are 9 homes going in across the street there. For a new community of people moving together, one of the commitments, and I believe that they will do it, is they'll allow that to be a center place for everybody to become more educated about that home, what that home means to this community, and also for us to fellowship together on those opportunities that we have that chance. So I respectfully ask that you listen to them. They've become some dear friends, and I can't wait for them to move in, just so you know. But thank you very much.
Thank you. Michael Leventhal, to be followed by David Springberg.
Hello, I'm Michael Leventhal, and up until 2 years ago, I was the Historic Preservation Coordinator for Arlington County. And during my time at the county, I probably assisted residents in over 300 cases of doing Tax Act credits from the state historic, from the Department of Historic Resources. Unlike in the county, the state looks at the interior and exterior of the house, and they do it through a very narrow prism of how they interpret their rules and regulations. While they do allow some changes, it is rare how they want you to move things around. This building was built in 1881 and has had about 6 major additions and changes through time. Bathrooms were brought in, kitchen was brought in, bedrooms were added, other spaces were added. It's not to say that the building isn't livable, it's just that there was no major long-range plan how the house developed. And so the circulation isn't necessarily how you would want to walk through the house, and the changes that need to be done for a modern family, for modern times, really need to be executed. Their proposed plan can meet the state's tax credit requirements. For them not to be able to get those tax credits is the hardship is that the project will probably not proceed. They can make changes to the building without the tax credits, but it's those tax credits which allow people to take on such an expensive and large project such as this. The integrity of the building is not going to be compromised. It will still be a great historic resources for the community, and I hope that you can approve it. Thank you.
Thank you. David Springberg, to be followed by Hans Berman.
Good evening. My name is Dave Springberg. I live at 1400 North Buchanan Street. I've lived in Woodlawn Waycroft since 2005, and I'm a former president of the Civic Association. I own the property behind Broadview at 5134 15th Street, and I developed, your pictures are kind of old, 2 houses to the right at 5135 and 5145 North 14th Street back in 2013. At that time, we tried to fix injustice that was done to Broadview. On the left-hand side of your picture, you see 2 pipe stem lots, or a lot and a pipe stem lot. There was a mirror image of that was carved out on the right-hand side of Broadview, and through a URD process and with concert with county staff and the HALRB, we tried to fix what was a bad situation or make the best of a bad situation and try to develop 2 new homes that were in deference and didn't completely close off Broadview. Also in that process, we gave Broadview another 20 feet of frontage, so it went from it was on a 20-foot wide pipe stem and became a conforming lot in Arlington, a 40-foot wide lot. Obviously, I support what the Browns are doing, and that I want to support them any way we can. The house has gone through a lot of indignities over the years, a lot of questionable design choices on the inside and renovations and subdivisions, and I commend the Browns for taking on this challenge. And the hardship for the neighborhood is if it doesn't happen, it will most likely get torn down, and we could end up with a McMansion on a lot that we have no control over what happens with. Thank you.
Thank you. Hans Berman.
Good evening. My name is Hans Baumann. I am a former president of Waycroft Woodlawn. Former president of the Civic Association. I live a block and a half away. On my block, there have been 3 houses torn down to build 4 6,000 square foot homes with 5 bathrooms. I considered buying Broadview 10 years ago when it first went up for sale in recent times, and didn't do so because it was too expensive a proposition to take on this project. I strongly support what the Browns are trying to do to retain Broadview's historic character while making it a slightly more modern home. It still is not going to have the 5 or 6 bathrooms that so many houses surrounding it will have. The one behind it that Dave Springberg just mentioned, plus on either side, plus across the street, the former Lacey Tract property now has 9 homes that are 5 or 6,000 square feet with 5 or 6 bathrooms. The house itself is the hardship, as far as I'm concerned. I would love to see us find a solution where, and I think the Browns have done everything possible, getting HLRB support, to allow them to modify their home to bring it up to current standards. It's something I wish I could have done, but I frankly just could not afford and couldn't figure out a path forward. I'm a handyman here in Arlington. I was working at 2410 North Glebe today in the house of a 102-year-old woman. She lives in a 1905 grand house with a big stairway in the middle and 4 big rooms off either side and the top upstairs and downstairs. A magnificent home that needs a massive capital investment. And it needs someone like the Browns to come and put the money and the effort into it to make it possible. And that's what Broadview has right now, and I think it would be a tremendous shame for us not to grant them a variance tonight and let them move forward with their project. Thank you.
Thank you.
That's the last speaker. Discussion? Questions? Ms. Malice?
I'm going to start with some nits, and then we can get on to the bigger, or not nits, but typically the BZA looks at neighborhood support, and so we have a petition and some letters from the neighbors, and I guess this is a question for the Browns. I don't see anything from 2 adjoining properties in the back, and it may be that I haven't gotten through all the I'm looking at 5144.
5134 North 15th Street, property in the rear.
That's not the one I'm asking about. I see your information. 5144
he
and
died.
5140. Okay.
And I've been trying I did track one person down in Bulgaria, but I've not been able to get the estate to respond. I did send a package, and I copied that and to Ms. Clement.
Okay, that's 5144. And what about 5140?
Is that the one in the kind of the...
That's immediately behind.
That's him.
That's him.
No, 5134 is the vacant. 5140 were the same parcel. It was a house.
5140 and 5134 are one parcel?
They were one parcel. They were owned by a common owner. The gentleman who owned the property died.
It's now being rented.
I'm looking at the plat here, and so I'm looking at house numbers. I'm getting a little confused because I see 5134. It has your permission. 5140 is just a different parcel. Is that yours?
No, it's an existing house. They were both owned by the common owner who died.
Both of these people died?
He owns one of them now. So, sorry. 5140 died.
5140 died.
5134, Dave Springberg owns.
I'm asking, and then I was asking about 5144.
I have not been able to reach them.
Okay.
I have knocked on their door 10 times, and nobody has.
Do you have any idea what that?
I don't know.
Okay. All right. So that's my nit, and I think you've answered. Those were the two that I had a question about.
Other questions? Hearing none.
I'm glad to speak to what I
Ms. Malice.
what I see here. I think I rarely support variances. I do consider them special privileges, and I use the stricter standard that Mr. Barnes has criticized, because I do think that they have a high bar, and I guess we'll continue to debate how high that bar is. Nevertheless, I think there is a reason to grant a special privilege here. I find the arguments about historic preservation compelling. I think that is a reason to grant a special privilege, because in Arlington County, we consider our historic resources a community asset, and we value them, and we have plans to value them, and we legislate laws to value them. So I personally happen to live in a historic district that also benefits from the tax relief that the Browns are seeking, and I know how tricky and difficult that is, and what a high bar that puts on a homeowner. And so I'm just putting out here right now that I think this is worthy of granting a special privilege by means of granting a variance.
Are you making a motion, or are we just discussing it?
I'm
Your
happy
pleasure.
to make a motion.
Anybody else want to make a comment before we get to that point?
I'll make a brief comment. So,
Mr. Melnick.
yes, I too, if a motion's made in favor of approving this application, I'd be for it, because I too, and I think there is a high bar for variances, as there should be. But here, this is a very unique combination of the oversized lot, the historic nature, the, just the arguments from the previous case that Barnes showed us, I feel like they apply. And so it's just, these different variables that are rather rare have all come together. So I'd be in favor of this.
Motion?
Madam Chair?
Ms. Malice.
I would like to move the alternate resolution. I move that the Board of Zoning Appeals adopt the attached alternate resolution
Approving.
Variance V-11198-16-VA-1 with conditions as shown in the alternate resolution.
Is there a second?
I'll second.
Moved and seconded. I would just like to make a comment, and that is that I lived in this neighborhood for 15 years, not really recently, but fortunately at a time when this property looked like it does in the photo. And I find the request modest and appropriate, and I only wish that other things had not popped up in the yard to block the view of what we see on this photograph and unhappily don't see as much of now.
Madam Chair?
Mr. Smith.
Just very, very briefly, about 30 years ago when I first moved here, I bought a house 3 houses down from Alcova House. And I always marveled at, A, the history, and B, the fact that I am living just on this property, literally. That's the value of Arlington. So clearly this is a difficult lot, and given the zoning ordinance being placed on top of it long after it was built. So I found it easy to support under, and thankfully the General Assembly did make some efforts some years ago to lower the bar. Though it's higher than use permit, it's lower than it historically was. And so it's easier for the granting of variances, so I don't have any trouble whatsoever supporting this.
Thank you. We have a motion to approve the alternative resolution granting the variance. Motion made by Ms. Malice, seconded by Mr. Melnick. All those in favor?
Aye.
Opposed? 401 present. Thank you. I think, given the nature of the agenda, while the room is clearing, we'll take a 5-minute break.
Thank you. Thank you for that.
Okay. I think I'll have a cupcake break.
Mr. Smith, did you see the cupcakes?
I'm staying away from you. You are, no. I have 5.
I was at Trader Joe's. I guess I could turn my mic off.
I looked for those. I was all set to uphold you. It's a problem. When I woke up this morning, I was going to uphold you. I figured that. I thought about it. I'm like, if I'm in charge. I was willing to give this applicant. Carry the majority. Now it's just noted. You can't put a pole. A basketball pole, but you can put a freaking garage. And that doesn't really make sense. Sorry you didn't participate. I'm not sorry. I'm glad you got what you needed.
Good night.
I was in the bathroom. How did that letter from Patrick Hope get distributed?
Oh, it was passed out, and they gave you a copy, didn't they?
Yeah, I got it. But I was wondering.
So I guess you saw my email.
She has to get back to my mother, who I guess.
Say hey, Michael.
She's wondering if we can move it up.
Yeah.
Good to see you.
16.
Or 213.
Yeah, 213, so yeah.
Yeah.
Deferral, yeah.
Well, you know, that's
Yeah.
20 years.
So we can move it up to the next one and then.
Yeah, I'll just, yeah.
She'll just approach the podium.
And there are no speakers.
Just her, or she's just gonna come and act that it be deferred?
Okay.
Yeah.
She's like that.
Well, let me make sure that there are no speakers.
Yeah. I forgot my gavel.
Yeah, you need a gavel.
I have one. When I retired from the planning commission, they gave me one. And I never bring it
Yeah.
when it could be used.
Let me straighten this thing up. This has gotten all screwed up.
Good to see you.
This board is all messed up.
Okay, ladies and gentlemen, we're ready to start. And we're taking an item out of order. It's item V11213-16-VA1. Personal privilege. Will you call the case, please?
This is V-11213-16-VA-1. This is a variance request to permit a setback of 8.9 feet to the wall from the South Garfield Street right-of-way instead of 25 feet as required for an addition to an existing non-conforming building in the RA 14-26 zoning district. The staff's recommendation was to adopt the resolution granting the variance with conditions.
Hi, I just wanted to see if I could defer it to a later date, because my mom, the owner of the house, she can't make it. She was operated a week ago. So I was wondering if I could push it back to a later date.
I'm sorry, Madam Chair, I didn't hear the number initially.
This is the 16th item on our agenda.
It's 11213-16-VA1.
The street address is 3000 16th Street South.
Okay, now, we do have one speaker. Carol Castro?
Yeah, that's my mom. She just got operated, so she couldn't come. That's why I wanted to see
Okay, I just want to make sure that someone didn't come out
I'm sorry,
in anticipation of the hearing.
did the speaker state her name for the record?
Oh, for me? Oh, yes. I'm her daughter, Tatiana Ruiz.
And do you know, do you have a suggested date for when you would like to have the hearing?
She should be fully recovered in a month, or even if it's like.
So would February work for you?
Yes.
Okay. Can I have a motion, please, for deferral?
Madam Chair?
Mr. Owen.
Before I make the motion, I just want to see if the zoning administrator has any concerns about a deferral to February. You okay with it? Is there an additional speaker?
Yes. Okay. You're here, but you did not fill out a form. Is that correct, sir? And why is it that you didn't fill out a form? Okay, would you fill out a form, please, and then you can come and speak. 2 minutes.
Is that it?
Madam, if you would just take a seat. Oh, great. Just write his name and address on a piece of paper Well, they don't have any.
Report.
Yes, please.
It says in the previous BZA action was in 1946. There was a BZA in 46?
There's record of a BZA case having been heard in 46, yeah.
That predates our zoning ordinance.
The current, the 1950 zoning ordinance, it does, yeah.
But there was another one that, there was a BZA. Interesting.
Okay, just to recap, the staff recommendation is to approve the variance. We have a request for a deferral to February. We are going to hear the speaker, 2 minutes, and then we'll discuss it. Please state your name for the record.
Yazan Jarar with Ideal Construction and Remodeling. We are actually the contractors for the homeowners. We unfortunately cannot be deferred to February because they just purchased the house. They closed on the house. They can't live in the house because of the construction that is proposed, and they have to leave their current apartment beginning of February. So they cannot actually move in until the job is actually done, or at least half of it is already constructed, so they can move in. That's why if we cannot reschedule till February. We're hoping for a decision tonight.
Okay, thank you. Oh, go ahead.
I'm a little confused. The applicant has stated that they are okay with the deferral.
She's not the
They are
applicant.
not the applicants.
But the applicant's daughter, that she's not, in other words, the mother is not, is there a misunderstanding?
Oh, yeah, she can't come right now.
But I mean, you said that it would be okay to wait till February. He's saying it's not okay.
My mom's Carol Castro, she owns the home. They're wanting to move the house. They're wanting to take a couple square footages.
Can you please come up and speak into the microphone, because we can't hear.
I was just asking to have it moved to a later date so that she could come.
Mm-hmm.
We're on the same property.
And February,
I think so. What property are you talking about? I'm talking about 3000 South 16th Street.
The next meeting of the BZA is February.
Point 16 or point 14?
No, I think that's another one you're talking
Madam Chair?
are we,
Mr.
Maybe an explanation to the applicant that her mother doesn't necessarily have to be here and that this
I think
speaker...
we're done.
Okay.
Oh, he's for the wrong case?
Yeah.
Okay. Is this case 14 or 16?
Mine's 16.
what number?
16 is the calendar year. You have to look at all of the numbers and letters. Okay.
Street address we're talking about is 3001 16th Road South.
Yes, that's the one I'm actually on right now.
Is that yours as well?
Mine is 3000 South 16th Street.
That's the same thing.
Yeah. Okay.
Do you two know each other?
No.
Okay.
So
We need to move on, so we need to figure out a solution to this, whether it's a deferral. Yes, Mr. Owen.
I do not see anybody in this room who has the authority to represent the applicant. So what I see before me is an application for a variance that has staff support, and as far as I can tell, no opposition whatsoever. And so the only thing I have heard from the applicant on the record for sure is in writing the application asking us to hear tonight this variance. It is not a requirement. It's strongly advised, but it is not actually a requirement that the applicant be present. And I am personally prepared to grant the variance right now because I don't hear anybody who has the authority to represent the applicant saying anything differently.
And Madam Chair, to ask, to follow up on Mr. Owen, are you Zaid? Okay.
Mike.
Thank you. You are, you're Jahar, but you're Yazan Jahar. Okay. All right. I'm Madam Chair, just to follow up on what Mr. Owen said, I agree with him 100%. I guess that was the point that I was making, and I too would support the approval of this application.
Okay, you guys may not know each other, but you're here on the same case, and it appears there's support for granting the variance, in which case there is no need for a delay or for your mother, when recovered, to reappear.
Okay, so it
Okay.
can't be pushed back?
We're not quite there yet. Could I have a motion, please?
I'm sorry, Madam Chair. I think the daughter is still confused about what's happening.
Yeah.
Well, it hasn't happened yet.
But she's asking for a delay. She continues to ask for a delay.
Yeah, well.
3000 South 16th Street?
Okay.
Because I have papers proving, because since they want to move it back, our property backwards, I have papers proving that my mom's paid several years for it and that the county has seen it.
So my question to you, I'm sorry, ma'am, could you state your name one more time?
Tatiana Ruiz?
Ms. Reese, what might be about to happen is for your mother to win her case
Okay.
today.
Okay.
Do you think she would be upset if she won her case today?
No, I know. She just told me to bring this just in case.
But she's making some claim, and I'm not sure what that claim is.
No, I'm just saying that I just have proof of her having, the counties, I don't know how to explain it, that they've seen it and that they've seen that that's still her property, that she's paid over the years. That's all I'm saying.
I'm not sure she's not.
Do you have any reason to think your mother would be upset if you went back to her tonight and said, you won, you never have to show up again?
No.
Okay.
Good. May I have a motion, please?
And before the motion, Madam Chair, is your mother Deborah Darcius?
No.
Who is your mother?
My mom's Carol Castro.
Carol Castro.
Yeah.
House 3000.
No.
3001.
Oh, are you speaking?
Not with the applicant.
Are you? She's a speaker. She's not the applicant.
She's a neighbor.
Asking.
Oh, the neighbor's asking for deferral.
A neighbor.
Be able to continue our construction right here on the same side. We're not.
Where do you live, ma'am?
3000 South 16th Street.
3000?
Yeah.
Okay.
Across the street,
Behind.
yeah, behind. Oh, and they're disputing the ownership. I see.
Not our,
Okay.
not our purview.
May I please have a motion for deferral? We can't work this out now, and it's not reasonable for everyone else here to listen to this confusion.
Wow.
I'm sympathetic to your point, Mr. Owen, but I don't think we can do that.
I was wrong on the facts. I'm sorry.
May I have a motion to defer, please?
Madam Chair, I move that the Board of Zoning Appeals defer item variance V-11213-16-VA-1 to the February BZA hearing.
Thank you. Second. Is there a second? I'll second. Moved by Ms. Malice, seconded by Mr. Melnick to defer this item to the February 2017 BZA meeting. All those in favor? Aye.
Aye. No.
4-1. Thank you.
Who was dissenting?
Mr. Owen, next case, please. Back to the regular order.
V-11204-16-UP-1 is a use permit request to permit a setback of 5.9 feet to the wall and 5 feet to the eave from the left side property line instead of 8 feet as required. Staff recommendation is to adopt the attached resolution granting the use permit with conditions.
Thank you. Questions for staff? The applicant, please.
Yes, good evening. My name is Frances Hudgens. I think this should be easy and straightforward. I'm representing the owners of the property at 3120 North Second Road who would like to add on to their home to make it function better for their family. They're adding on in a few areas. At the front porch, they're adding a covered stoop. In the back, a family room, 10 feet by 30 feet with a small back entry, a deck to the east of that entrance. They're putting on the west side of the house a basement egress. All of those are conforming, and we would like to add, the non-conforming addition we'd like to add is a 2 by 16.5-foot overhang, a bay overhang, which adds closet space to the master bedroom. The eave will be 5 feet from the property line, and the exterior of the closet wall would be 5.9 feet from the property line. And of note, this addition here will be a bay as opposed to having a foundation, because we want to preserve a window below it. And this is the area we're asked to be considered for variance.
Thank you. Questions?
Madam Chair, I'm ready to make a motion.
Speakers?
Speaker again.
We have a speaker? No, that's you, Francis.
That's me, yeah.
Got it. Excellent.
Madam Chair, I'm ready to make a motion.
Mr. Owen.
Madam Chairman, I move that the Board of Zoning Appeals adopt the attached resolution approving use permit V-11204-16-UP1, subject to the conditions listed in the resolution.
Second.
Moved by Mr. Owen, seconded by Mr. Smith. All those in favor? Aye.
Aye.
Opposed? Thank you.
Thank you.
Next case.
Next case, V-11205-16-UP-1. Use permit request to permit a setback of 18.6 feet to the base of the porch instead of 21 feet as required, and 18.1 feet to the eave instead of 5 feet as required from the 12th Street South right-of-way for the new front porch. Staff recommendation is to adopt the attached resolution granting the subject use permit with conditions.
Thank you. Questions for staff? Hear from the applicant, please.
Thank you so much for taking the time to speak with us this evening. My name is Elizabeth Falke. This is my husband. We are owners of the property here. We've been in South Arlington for, I guess, about 6 years, and part of the reason that we bought this home was for the front porch opportunity. So we're hoping today to be able to put in a porch that we believe will add to the appearance of the home. It is a bike lane street, so we do get a fair amount of traffic that we would like to encourage other South Arlington residents to see how beautiful it can be and sit out there and enjoy evening cocktails and lemonades.
Questions for the applicant? Hearing none.
Madam Chair.
Mr. Smith.
I'd move that the Board of Zoning Appeals adopt the attached resolution granting the use permit in V-11205-16-UP1, subject to the conditions that are listed in the staff report.
Second.
Owen.
Thank you. Moved by Mr. Smith, seconded by Mr. Owen. All those in favor?
Aye.
Aye.
Thank you.
Madam Chair, if I could.
Mr. Melnick.
Oh, for the applicants,
Ms.
There
Falke,
they go.
Mr. Deutsch.
yes. Oh, I just wanted to commend you on your design. It's a great improvement, and it's a, I love front porches, and it looks wonderful.
Thank you very much.
Thanks.
Thank you. Next case, please.
Next case, V-11206-16-UP-1. Use permit request to permit a setback of 15.6 feet to the window, to the bay window from 23rd Street South right-of-way instead of 23.5 feet as required, and 15.4 feet to the eave from the 23rd Street South right-of-way instead of 21 feet as required for a new bay window. Staff recommendations to adopt the attached resolution granting the use permit with conditions.
Questions for staff? Hear from the applicant, please.
Do you have questions for me, or do you want me to present what's here.
Just, you can tell us whatever you'd like us to know.
Yeah, we just want to install a bay window, which doesn't meet the setback requirements because the house itself was built before there were that requirement. So that's our request.
Okay, thank you. Questions for the applicant?
I'd like to make a motion.
Mr. Melnick.
Okay. In case V1120616UP1, I'd move that the Arlington Board of Zoning Appeals grant the use permit as shown on the attached resolution with conditions.
Second.
Moved by Mr. Melnick, seconded by Mr. Owen. All those in favor?
Aye.
Thank you. Next case, please.
V-11207-16-UP-1 is a use permit request to permit a setback of 22 feet to the wall instead of 25 feet as required, and 20.5 feet to the eave instead of 21 feet as required from the 17th Street North right-of-way. This is for the enclosure of an existing porch. Staff recommendation is to adopt the attached resolution granting the subject use permit with conditions.
Thank you. Questions? Applicant?
Hi, my name is Patrick Gutierrez. I am the owner of the property. All we want to do is drop down walls on our existing covered front porch. And because we're dropping down walls, we need the use permit because the distances are different. We're not changing the footprint of the front porch at all, and we just want to make it into a four-seasoned reading room, essentially, for my mother-in-law. So,
God bless you. Any questions?
Yeah, I just, you had a couple of letters of petitions on your of support, and one is 4616.
yeah, I messed up. I wasn't. I was rushing to get those letters, and honestly I feel stupid because I don't even know my neighbors' technical addresses when I was trying to fill them out, and they forgot to put the addresses themselves, and they were supposed to, I think, on the form they were supposed to put the addresses when they ended up putting the date.
Okay.
And so when I got here to turn it in, I was scrambling to figure out what it was because I wasn't at home. I was in the office.
Okay.
I apologize if I messed up the addresses, but they're...
It should 4616, it should be 4614.
Yes.
Your next door neighbor.
And then the one next to...
The other one on the corner, I understood.
And I think that
Yeah.
that might be a Glebe Road one.
Okay.
And they just simply didn't realize they were supposed to put the addresses. And then when I was here, I struggled to figure out what the addresses were. I was just guessing.
No worries. Okay, thank you.
Sorry about that.
Any other questions? No? Sure.
Madam Chair?
Mr. Smith.
I move that the Board of Zoning Appeals adopt the attached resolution approving the use permit in case V-11207-16-UP1, subject to the conditions that are listed in the staff report.
Second.
Moved by Mr. Smith, seconded by Ms. Malice. All those in favor?
Aye.
Aye.
Thank you very much.
Next case, please.
V-11208-16-UP-2 is a use permit request to permit a setback of 5 feet to the addition from the left side property line instead of 10 feet as required, and for an aggregate side yard of 15.6 feet instead of 18 feet as required. And this is for a new two-story addition. The staff recommendation is to adopt the attached resolution granting the use permit with conditions.
This is the same as 2015?
It's slightly modified from the 2015.
So the 2015 was not built?
No, actually, I almost made it through my second round of permitting when my time expired.
Sorry about that. Okay. Questions for the applicant? We'll hear from the applicant, please. Okay. Anybody have any questions for him?
Let me ask similar. Your next door neighbor lives at 720?
Correct.
I don't see anything from him.
Oh,
or her.
actually, it's from her. She's been hospitalized.
Okay. So does she know about it, or is she?
Yes.
Yeah, you've spoken to her about it.
But
she wasn't available to sign off.
correct. She's actually lived next door to me the whole time I've been there, which is now 28 years.
And just to clarify, the addition is not on her side, though. It's on the side where you, so you have a signature from the neighbor who's most affected. Is
Correct.
that right?
That's 28, which is...
728,
the
the
first
corner.
one. Yeah.
Got it.
Which is
Okay.
really the one who's most affected, yes.
Sure. Okay, any other questions?
Madam Chair, I move that the Board of Zoning Appeals adopt the attached resolution approving use permit V11028-16-UP-2, subject to the conditions listed in the resolution.
Second.
Moved by Ms. Malice, seconded by Mr. Smith. All those in favor?
Aye.
Thank you.
Thank you.
Next case, please.
B-11209-16-UP-1 is a use permit request to permit a setback of 17.5 feet to the base instead of 21 feet as required, and 16.9 feet to the eave instead of 19.5 feet as required. This is from the 12th Street South right-of-way and for a new front porch. The staff recommendation is to adopt the attached resolution granting the use permit with conditions.
Any questions for staff? Applicant?
Good evening. My name is Jean Shim. My husband and I are the owners of this house. We lived here for over 10 years, and we live in a very friendly neighborhood, and we often just sit on our front stoop. So we just use a covered porch where we could sit with our children, and it adds curb appeal. And
Thank you. Any questions? Yes, Mr. O?
I'm going to make a motion to grant the use permit, but I would like to note that this request is for slightly closer to the curb than any of the precedents that were listed in the staff report. And this particular property has extreme topography that may justify further deviation. But in case anyone ever listens to this tape, which is extremely unlikely, I guess, but in case anyone ever listens to the tape, I'm not sure that this distance ought to be a precedent for everything in the future in this neighborhood. Because it has these special conditions. So I just wanted to go on the record saying that. And with that, I will make a motion.
Thank you.
I move that the Board of Zoning Appeals adopt the attached resolution approving the use permit V-11209-16-UP-1, subject to the conditions listed in the resolution.
Second.
Moved by Mr. Owen, seconded by Mr. Smith. All those in favor?
Aye.
Aye.
Thank you. Next case, please.
V-11210-16-VA-1 is a variance request to permit a setback of 8.3 feet to the wall of an existing structure and 9 feet to the wall of a proposed addition instead of 10 feet as required from the left side property line, and a setback of 17.5 feet to the existing enclosed porch from the South Beach Street right-of-way instead of 25 feet as required, and to permit an addition exceeding 50% of the aggregate floor area of the existing building on a lot that does not meet the area requirement of the RA 8-18 zoning district. The staff recommendation is to adopt the attached resolution granting a variance to permit a setback of 8.3 feet to the existing wall, 17.5 feet to the existing enclosed porch, and to allow for an addition not to exceed 417.5 gross square feet, and denying the variance for a setback of 9 feet to the wall and for an addition exceeding 50% of the aggregate floor area of the existing building.
Thank you. Questions for staff? Applicant?
Actually, I do have a
Mr. Owen.
question. We just tonight got a letter from a neighbor on this property that enumerates a detailed list of the neighbor's position. And because staff might have had a few extra hours to read it ahead of us, I'm just wondering if staff has a view as to whether or not you think the neighbor is supporting the staff position. And the neighbor may be here to speak for him or herself, but just as an overview, do you have the impression that the neighbor is supporting the staff position or setting forth yet another position?
They don't support the coverage. I mean, the 8%.
I believe that they're supporting the staff recommendation.
Okay. And I'll let if the neighbors here, they can speak for themselves as well, but it was a lot to read through during the meeting.
Ms. Malice?
I noticed that in the staff report, there are no neighbor comments. Did you get comments from your neighbors?
Did I get what?
Did you get comments? Did you show your neighbors the plans and get comments from them?
My real estate agent who knows the neighborhood, they went door to door and asked the neighbors. All the neighbors are in favor.
Did he document that?
I believe she has.
Do you know where that documentation is?
I have my agent here. Yeah, she has their.
Were you aware that we look for documentation on neighbor support?
I believe the agent told me that the neighbors are going to come here. Some of the neighbors may be here. We didn't know they're here or not.
Well, we have 2 speaker slips, but nevertheless, it's important to have input from all of the surrounding property owners, which is something we apparently don't have. So, as the applicant, would you give us your presentation, please?
Okay. My name is Wai Chang Wen. I'm the owner of the house. Thank you all for your long working hours and service. The current house is built in 1940. It's a 2-bedroom, 1 bathroom, no basement, very small. And the previous owner living there for 40 years did not make any improvement. So the house is in very bad condition. So I would like to improve the house and also build addition to it, so the house becomes a 3-bedroom and 2-bathroom. If any family want to move into this kind of house, the 2-bed and 1-bath is not enough. It's too small. And this lot is like 2,700 square footage. Even with addition, we still have 37 feet in the backyard towards the setback. So it's I think it's a better use for this house, for this lot, and the addition is for better benefits for this house and for the neighbors. I believe all the neighbors, some of them already did the addition, even bigger addition than I proposed. Some other neighbors are planning to do it, and I believe the neighbors should have the option to do this. If this case gets the variance gets approved, it will benefit this house and all the other houses surrounding and the neighborhood. So that's why I propose this. Thank you.
Questions for the applicant? We have 2 speakers. The first one is Margaret Aston, to be followed by Stephanie Pryor.
I'm Margaret Aston, and my husband and I are real estate agents in the Penrose neighborhood, and we have spoken to several neighbors over the course of several months. We knew the previous owner. We listed his home and had several offers on the house, well above the asking price. And the neighbors we spoke to are in favor of allowing the variance request. And in order to be more congruent with the size and value of neighboring houses who have already done additions, at the current size, there really needs to be an expansion of the house in order to bring it up to date and up to size of other houses in the neighborhood. And I have the names and addresses of people who we spoke to specifically who were in support of it.
We're going to need those.
Does that include 311, which has a common wall?
No, they're renters. The owner, they've rented the house for at least 20 years. So the owner, we didn't have an opportunity to speak to the owner.
Ms. Malice?
How do you propose to provide that documentation to us as to who you spoke to?
Well, some people said they were going to be here tonight. I mean, I could, put it in writing and ask them to sign it, but, I thought.
Typically, we either get letters of support or a petition is circulated so that we have written support from the affected neighbors.
Okay, well, I don't have that information.
Okay, thank you. Stephanie Pryor?
It's only showing 45 seconds.
But what happened? Hang on.
You get an extra.
I'll take the 245. Good evening. My name is Stephanie Pryor, and private citizen, not my usual civic hats. My property is 501 South Wayne, which was called out as a comparative example in the applicant's letter. It is not an accurate comparison. I stayed within the setback restrictions. My addition is 14 by 18 with exterior measurements. Another property referenced is a 1-story, not a 2-story, so that the family could actually stay there while her husband was incapacitated. And she also had the proper 10-foot setback. The 309 property has an enclosed front porch and a fully asphalted driveway extended to the back of the house. My driveway is gravel, and I convinced my neighbor to retain the gravel in order to remain the permeability. The claim for just 10 shirts in the closet and tiny kitchen is accurate. We have 2, 3, 4, and 5 member families in our neighborhood. We appreciate our small houses, and we think they're large enough. We do, unlike Adam Street and Penrose, this applicant has not presented a letter of agreement from his neighbors, nor does he present accurate examples for the comparison. So as stated before, I do have 501 South Wayne. I did an extension in order to get my mom to move in from her large Texas house, and she's still living there. Thank you.
We have one more speaker, Daisy Peralta.
Hello, my name is Daisy Peralta. I own the property at 300 South Courthouse Road, and we bought the house back in 1975. And the reason that we bought the house is because of the location, and it brought us here because my husband was in the military, and also as an investment. So I'm here tonight and oppose the. I was told that they're going to convert this, make an addition, and convert it to a rental property. So by doing that, it will affect the value of our property. So I'm against about the addition of this property. Thank you.
Thank you. Any other discussion or questions?
Madam Chair, I am concerned that we don't have neighbor input, and it appears that there is some controversy in the neighborhood on this project. So typically what we would do in a case like this is to ask for a deferral, to vote a deferral, to give the applicant time to collect whatever support they have for the project.
Okay. That's your pleasure.
Madam Chair.
Mr. Owen.
I would be interested in the applicant's view on a deferral. Would you mind coming up to the podium? Yes, I'm asking you a question. And my question is, would you accept a deferral? Are you willing to take a deferral to allow you more time to talk to your neighbors?
I have been waiting for 3 months. The house is empty, and next one is going to be 2 months later. As me and my architect, we talked to Amanda with the county last week. Actually, this Monday, we would not want to delay another 2 months because this small house is. We would like to renovate and finish the house as soon as possible. If we delay for another 2 months, and then after we building the addition, it's going to be past summer. It's going to be in a bad, in not as good market. For your information, we do not intend to rent this out. I don't know why she heard we plan to rent it out. We're going to put on market for, this house is next to the Army base. I hope if any Army people or anybody else who with a family with one kid, they will love 3-bedroom, 2-bath much better than 2-bedroom, 1-bath. That's my plan.
One thing that may happen, though, is that if you demand us to vote tonight, we may say no. So the question is, do you want to ask us to vote tonight even if we say no, or would you like more time if that would mean bringing your neighbors on board?
Can I add another point? During the discussion between me and my architect and Amanda had another resolution, which is ask the board give us not what we proposed, but a smaller version of what we proposed, like based on Amanda's recommendation, we not asking as much, but we only increase the house addition area by half of the existing square feet, which is 417.5 square feet. If that's what Amanda, the county BZA zoning people recommended, if you could consider that, I would really appreciate it.
Thank you for answering my question.
I believe that we would have to have drawings of an alternate proposal.
We have the alternate drawings of proposal.
We don't have them.
We don't have them.
I can send it, give it to you right now.
I was going to raise the issue of 88% and suggest that particularly if there's a deferral, that they come back with something that not only reflects neighborhood input, particularly the people with a common wall, but also something that to which the staff would not object on the size of it.
So I will say, in speaking with the applicant on Monday, because we went over what the staff was recommending, they understood what our recommendation was going to be, and I do believe that they have proposed an alternate design, which hasn't been submitted with their package, that we felt like would meet the intent of our recommended resolution. I think that he would be prepared to offer that this evening, but it is something that we saw for the 417 square foot recommendation.
Well, I think it's good that it exists and that there seems to be some point of agreement, but it's not on the table. We haven't seen it, and the neighbors haven't seen it, and the neighbors haven't, formally given us their feedback. So I think it's crying out for a deferral.
Thank you.
And Madam Chair, if I might just add to that, and I appreciate hearing that from staff, but I think the point that Ms. Malice raises is especially critical in cases where you share a wall.
Yep.
You absolutely have to have something in writing from that person. Whether they live somewhere else and someone rents that property or not, it really doesn't matter. There has to be some indication that there was contact made with that person when they're not just, you can't get any more directly affected. I'm not as uncomfortable with the absence of a plan, but especially having heard that staff has seen something, but I think that it's really critical that you have some indication that the neighbor who shares a wall has seen the plan and has had an opportunity to make a comment about it, and that evidence is presented to us. So I'd support deferral.
May I add something? I'm confident, based on my agent's feedback to talking to the neighbors, and also I left a note to the next door neighbor, the share wall neighbor, and I talked to trying to talk to the tenant. Nobody called me. Based on my belief, the owner who lives in West Virginia, he does not care. But I'll follow your suggestion. I'll try to reach him for the next 2 months. But I do believe she's an old man, and I mean, he's old man, he don't really care. And we are on the north side, our addition will not block any sunshine for his backyard.
Excuse me. I would say, just speaking for myself, if the abutting neighbor does not sign something, does not provide writing that expresses his opinion, the owner, then I would be interested to see documentation for what the attempts were to reach the owner.
Okay.
Instead of that.
You
So
know,
the
a
best thing is to get the owner to actually put something in writing, but if that's impossible, then documenting your efforts to reach the owner is something I would personally be interested in seeing.
Okay, thank you.
Can we have a motion, please?
Madam Chair, I move that we defer V-11210-16-VA-1 to the February BZA hearing.
I'll second.
Moved by Ms. Malice, seconded by Mr. Melnick to defer the subject until the February BZA meeting. All those in favor?
Aye.
Thank you.
Thank you all.
Next case.
V-11211-16-UP-1 is a use permit request to permit a setback of 5.8 feet to the wall from the left side property line instead of 10 feet as required, and an aggregate side yard of 13.5 feet instead of 18 feet as required. This is for a second-story addition over an existing non-conforming garage. The staff recommendation is to adopt the attached resolution granting the subject use permit with conditions.
Thank you. Questions for staff? Hear from the applicant, please.
Madam Chair, I have a question for
Mr.
staff.
Owen?
In the staff report, there's an assertion that this would be a by right addition if it were not over the garage, and I was confused by that assertion. This appears on page 2 below the table, the second sentence. Staff also agrees that a similar outcome could be achieved by right if the structure below the addition was not a garage. Why is that?
I believe what that statement was intending to state was if it wasn't a garage but just a first floor portion of the house, then they would have the by right option to build straight up. Obviously, it's the fact that it's an encroaching non-conforming garage that's limiting them from doing that.
It's not any garage, it's this particular garage?
It's the fact that the garage is non-conforming.
So if there was a conforming, we've talked about this earlier, a conforming building below of any kind, garage or non-garage. See, that's the thing that would confuse me. It seemed to suggest that that whether or not the building was a garage was the key fact, as opposed to whether or not the building was conforming. So what I'm hearing from you tonight is that it's not really whether or not it is a garage, but whether or not the building is conforming or not. But that seems to be different than what's actually written there. So that was my confusion. Oh, okay. So Mr. Melnick is pointing me to the ordinance requirements section, final sentence, and providing that new construction may not take place over encroaching garages or porches.
So it would be true if it was a porch as well.
Correct.
It's not a garage per se.
Non-conforming garages or porches.
It's a non-conforming structure.
Got it.
I also have a question for staff. This is kind of procedural. You are recommending adoption of the use permit, but there are no comments from the neighbors. Do you take that into consideration when you develop your recommendation?
Whenever we're developing the recommendation, we're taking into consideration the criteria. We do encourage and ask our applicants to provide that information, but we're looking at the criteria as it's defined in our ordinance whenever we're preparing the report and a recommendation.
Hear from the applicant, please. Do we have an applicant for this item?
Oh, that's from
11211, Shahruz Shams. really.
Madam Chair,
Mr. Owen.
I move that we defer this item to the February meeting.
Second.
Moved by Mr. Owen, seconded by Mr. Smith to defer this item to the February 2017 meeting. All those in favor?
Aye.
Aye. Thank you. Next case.
V-11049-15-UP-2 is a use permit request to amend a previously approved use permit and to permit a setback of 4.1 feet to the eave, 5.4 feet to the wall from the right side property line instead of 8 feet as required. This is for a new two-story rear addition. The staff recommendation is to adopt the attached resolution granting the use permit for a setback of 4.1 feet to the eave and 5.4 feet to the wall.
Questions for the staff? Applicants?
Good evening. My name is Lauren Ford, and this is my husband, Jonathan Ford.
Good evening, Madam Chairwoman, staff, and board. We're here tonight a little bit with our tail between our legs. A year and a half ago or so, the board was kind and gave us a waiver for our addition. Over the course of the construction, we went over by a couple of inches in the process. Very long story.
You're looking appropriately contrite for 10:10 in the night.
Our contractor, upon signing the contract, told us that he had cancer. So they wanted to honor the contract, and he said his partner would follow through and uphold that contract, which he did. Unfortunately, because he was then supporting all his own projects as well as his partner's projects, a couple things fell through the cracks in addition to getting the wall check in a timely manner and thus the error of a couple of inches. Sadly, actually, our contractor passed last week. So in that light, we wanted to ask for permission to grant an understanding of that error of a couple few inches this evening.
I have additional letters from neighbors. I have an email from our next door neighbor who's probably mostly greatly affected by it. And thankfully, I have members from the neighborhood that came out tonight in support. I think they're going to say a few things that could be good, it could be bad, depending on mood.
Okay. If you want to bring the letters up, I'll put those in the record.
We did get a packet, a supplemental packet at the beginning of the meeting as well.
Yes. Okay, thank you. I have 4 speakers. Want to take a seat? Dr. Edward, you can tell me your last name and put when you get up here.
Labello, Edward Labello.
Thank you.
We're a neighbor across the street, and just quickly, we are very supportive of what they're doing with the house, of their request.
Excellent, thank you. Stephen Combs, to be followed by David Baird.
Good evening. We're the neighbors across the street to the right. We love our neighborhood, and we love the Fords, and we're very supportive of what they're doing.
Address?
709, ma'am, to the front and to the right of their house.
Got it.
Thank you.
Thank you.
Thank you. David Baird, to be followed by Aaron. Oh, dear. Aaron, you can enter your name in the record, too.
Good evening. I'm David Baird. I live at 727 26th Street, which is the backyard, adjoining backyard neighbor. I fully support the Ford's variance and ask you to support them tonight as well. The addition looks great so far and it'd be great to complete it.
Thank you. I apologize. It's late.
Good evening. I am Aaron Simakopoulos. I am a neighbor of John and Lauren Ford. I rented the 720 25th Street home a couple of years ago. That's the home that's mostly affected. And I don't think that this would be an issue at all for anything to do with that home. And as of this morning, I'm the proud owner of 712 25th Street, the one on the other side of John and Lauren's home. And I have no problems with this at all, and I encourage the board to approve it. Thank you.
Congratulations. Thank you. Questions, comment? Mr.
I wish
Smith.
some of those other applicants who didn't have any support from their neighbors evidenced had seen this, because this is a clear example of outreach that I'm sure you've had to do over the course of a year and a half or so. And here you have them here. They are to be commended because there's no interest that they have in this other than supporting you as a neighbor.
Exactly.
And that those other folk didn't see that, I think, is kind of
Unfortunate.
does you a disservice, because you did what we really want people to do and provide a good example.
For the record, I live in the best neighborhood, in the best town in the Commonwealth of Virginia.
Here, here. May I have a motion, please?
Chair,
Ms. Malice.
I move that the Board of Zoning Appeals adopt the attached resolution granting the use permit with conditions attached.
Second.
Moved by Ms. Malice, seconded by Mr. Smith. All those in favor?
Aye.
Thank you. Next case, please.
V-11212-16-UP-1 is a use permit request to permit a setback of 20 feet from the South Adams Street right-of-way instead of 21 feet as required for a new front porch. The staff recommendation is to adopt the attached resolution granting the use permit with conditions.
Thank you. Questions for staff? Applicant?
I'm Kane Fabney. I'm the owner. I don't really have anything additional. I just wanted to present myself for questions.
Thank you.
Madam Chair,
Mr. Owen?
I'm prepared to make a motion.
Thank you.
I move that the Board of Zoning Appeals adopt the attached resolution granting use permit V-11212-16-UP-1, subject to the conditions listed in the resolution.
I'll second.
Moved by Mr. Owen, seconded by Mr. Melnick. All those in favor?
Aye.
Thank you.
Thank you.
The next case we have already addressed. Next case.
V-11214-16-UP-2 is a use permit request to permit a setback of 4.5 feet to the eave and 5 feet to the wall and balconies from the right side property line instead of 10 feet as required, and 4.5 feet to the eave and 5 feet to the wall and balconies from the left side property line instead of 8 feet as required, and 17.8 feet to the stairs, 19.8 feet to the rear patio, and 20.8 feet to the rear balcony from the rear property line instead of 21 feet as required, and an aggregate side yard of 9 feet instead of 18 feet as required. This is all regarding a 3-story detached single-family home with second and third floor front balconies, second and third floor rear balconies, a raised rear patio with stairs, and a rooftop deck. The staff recommendation is to adopt the attached resolution granting the subject use permit with conditions.
Madam Chair.
Mr. Owen?
I wanted to say for the record that I am acquainted with Ms. Obakoya, as she has been a county staffer with whom I worked from time to time when I was on the Transportation Commission. Nonetheless, I do feel that I can fairly weigh the facts and law in this case, and so I will participate anyway.
Thank you. Questions? Comments? Applicant?
Hi, my name is Bridget Obikoya, and I am the owner of the lot. And I was here last October 2015 asking for permission respectfully to approve the application, and it was approved. However, I did not complete my design documents and get all my lending done within the 12-month period. So I'm back here asking for permission again to please accept my request for application with one slight modification. The rear lot that was requested before was deeper into the lot. I pulled it back some so that I could have more of a backyard. So it's actually in more compliance than it was before. And I've also requested 2 feet in height because of the narrowness of the site. But it's still well within the 35 feet that I'm allowed to build, and with the understanding that my neighbors could also build up to the 35 feet.
Thank you. Questions for the applicant?
Madam Chair.
Mr. Smith?
I don't think it would be prudent to require you to go back But I presume that the neighbors know that, well, it didn't get done in time, and so you're going to reapply, and they're still supportive.
Well, I have been in constant communication with the neighbors because my son went to school in the neighborhood and he plays basketball with a couple of boys on the street, and I'm familiar. So I'm in contact with them, and I've told a few, but I haven't told all of the ones that I've reached out to initially. But most are familiar. And I did speak with Civic Association President and other members of the Civic Association, so they know as well.
Thank you. No speakers.
Madam Chair,
Mr. Smith.
I'd move that the Board of Zoning Appeals adopt the attached resolution granting the use permit in V-11214-16-UP2, subject to the conditions that are listed in the staff report.
Second.
Moved by Mr. Smith, seconded by Ms. Malice. All those in favor? Aye. Thank you.
Very much.
Thank you. And we have our last case.
V-11215-16-UP-1 is a use permit request to permit a setback of 6.4 feet from the right side property line instead of 8 feet as required for a new screen porch. The staff recommendation is to adopt the attached resolution granting the subject use permit with conditions.
Thank you. Questions for staff? Applicant, you put in a speaker slip, right?
Yes.
Okay.
Good evening. My name is Stephen Galusha, and we're requesting to rebuild the screened-in porch that was existing prior to the two-story addition that we put on. We're going to rebuild it. We would like to rebuild it with the same footprint, and we took it down so the heavy equipment could get back to dig the foundation. Didn't want to disturb the neighbors' lots, and we could only go in on that right side if you're looking at the house, because the left side is a narrow wall, basically.
Okay.
And I have one other letter from the neighbor directly behind us that I couldn't get in time for the application.
Yes, please.
That's 5716.
Thank you. Yes, 5716 Wilson. Okay. Questions for the applicant? We have one speaker. I presume that might be the gentleman standing next to you, right? Is that correct?
Yeah, I'm Tim Van Vano. I'm the one who did the addition, so I just came along if anything needed to be answered, but we had to take it out in order to get back to the property in the back.
Well, I assumed that when I looked at it, it wasn't there. So, okay. Okay. Any questions for either of these gentlemen? Okay. Mr. Owen.
I'm sorry. If there are no questions, I'm prepared to make a motion.
Please.
I move that the Board of Zoning Appeals adopt the attached resolution approving the use permit V-11215-16-UP-1, subject to the conditions listed in the resolution.
I'll second.
Moved by Mr. Owen, seconded by Mr. Melnick. All those in favor? Aye. Thank you. Thank you for your patience.
Thank you.
Okay. We have minutes from November 16th. And, well, let's do the minutes first, and then I have something else.
Chair, with regard to the minutes, in the first item recorded in the minutes, I did not participate in the vote. I voted present, and I noted my recusal from the matter, but that's not reflected in the draft minutes.
Okay.
I would, at the appropriate time, I'll make a request to make that change to the minutes, that the minutes record a vote of 4-0 with Mr. Owen voting present, and also that I noted that I was recusing myself.
Okay, so noted. That would be changed. Anything else? Any other comments before? Okay. Can we
Madam
accept them with that change, or do we need to start over?
I'll make a motion if you would like.
Yes, indeedy.
Madam Chair, I move that the minutes be accepted as proposed by the staff, except with the aforementioned change regarding the 4-0 vote and recusal in the first item.
Second.
Moved by Mr. Owen, seconded by Mr. Smith, with the corrections noted by Mr. Owen. All those in favor?
Aye.
Thank you. I did have one comment on the opening remarks with which Mr. Lawson took exception. and which, of course, I simply read as submitted. So would you look into that, whatever it was that he raised, because he, well, it was something to do with a court case.
Madam Chair?
Yes.
I believe that you actually corrected it. I believe that Mr. Lawson's comments were overtaken by events. My understanding of what happened is that we had been reading outdated description of the law, that there was after the last meeting, I mentioned that to staff and suggested they provide you with new language. They did.
Yes.
And I suspect what happened was Mr. Lawson was thinking about the last 10 times he heard it wrong,
Okay.
and not the current time that he wasn't listening and heard it right.
Okay, since he took me to task personally, not in an ugly way, but nevertheless, he said, you said. And so I wanted to be sure that if this new script is not correct, it's corrected, but if it's, I certainly accept Mr. Owen's interpretation, and I will forgive Barnes for his remarks. Thank you. I'd like to wish everybody a merry everything, and I'll entertain a motion for adjournment. Thank you. We're adjourned. Thank you. See you in February. I assume in January we'll find out what our schedule is.